This item two, I'm just time being accommodation. There's one matter in court number one, I'll come back.
Made please, Your Lordship. Your Lordship, I beg to mention item number 57 and 58. Your Lordship.
What are these matters?
Also, there's some difficulty on part of senior counsel with the claim shorted today. Your Lordship.
The 2019 matter, it should not be adjourned.
For a week, Your Lordship.
No, it's a 19 matter. Why should it be adjourned? 2019 matter, why should it be adjourned?
So some difficulty today, Your Lordship, for a week.
No, difficulties of the system also. We should finish off the old matters. It's a difficulty of everybody, not just one person. You appear for the other side.
No, Lordship, I've informed the other side.
Who appears?
Mr. Tonai Chakraborty, Your Lordship.
Sorry?
Tonai Chakraborty, Your Lordship. I've informed him, Your Lordship.
What information? You do? But we don't appreciate this
Okay.
whole matters being adjourned for nothing.
Lordship.
Your name?
N. Gautam, Your Lordship.
And
Gautam, Your Lordship.
Gautami.
Gautam, Lordship.
Gautam.
Lordship.
Adjourned on the prayer, Mr. N. Gautam. Non-conventional for an appellant.
Lordship.
I'm planning for listing this matter on Monday.
Listing.
May it please your lordship. May it please your lordship. Lordship, I beg to mention item number one, lordship. Lordship, today I will file the additional affidavit.
Item number one.
Yes, lordship.
What do you want?
Lordship, kindly take up this matter on Monday, lordship, 24/7.
Your name?
N. Dekaraja, lordship.
N. Dekaraja, petitioner adjourned.
Much obliged.
Yes.
Lordship, I beg to mention item number 15 of today's case. Well, in this case, I have to file affidavit, my lord.
Let the item be called, we'll pass to it.
Item 5 for admission.
That matter. Who will appear between Mr. Sheikh and Mr. Mahmood? Ultimately, it was concluded that Mr. Sheikh will appear. Where is he?
Probably this case, Mr. Sheikh will appear, my lordship.
Ultimately, there was a confusion between Mr. Mahmood and Mr. Sheikh. Who will appear? Ultimately, they settled Mr. Sheikh will appear.
Yes.
So where is Mr. Sheikh now? And these 17 matters we don't want to adjourn. We dismiss for non-prosecution.
Well, Mr. Mahmood will not appear in this matter.
We know that it's already called. None appears for the appellant. Dismissed for non-prosecution.
Item 6.
None appears for the appellant. List again in the next week. In the event of further non-appearance, adverse order shall follow. First time I said, yes, Mr. Mutin.
My lord, grandfather name is my lord Haran Ali.
Page number.
Page my lord 18, my lord. Voter list 1966. Page 18 and 19.
Here to the CBD. Easy as the adjournment lole. Adjournment granted. With a reservation that it's a matter of 2019, list on so and so, no further adjournment. Page number, Mr. Moti?
Page 18, man.
18. The list of 1966.
Yes, ma'am.
Haran Ali. Haran Ali is the father or
Grandfather.
grandfather? Village, Helengor. Who is the father?
Page 24, my lord.
Page 24.
816 grandfather.
Sorry. Haran Ali is a grandfather.
Grandfather and 822.
Sorry,
822.
Habibur
serial
Rahman.
number. Yes, Habibur
He is the father.
Rahman.
Is it of the same village?
No, my lord. Shifting village.
Then what happened? What will you want to do? How do you prove the shifting?
Yes, my lord.
What will be taken into a case? Madam Verma, but the other people are same. Haran Ali, son of
Same,
Arifullah, Bhanu Nisa, wife of Haran Ali.
And Banagular.
These two names appear in 1966 also.
Yes. Page 25 Banagular mines.
There is a possibility that there actually may have been a shifting. What do you do?
It can be remanded back, lordship, and we can then prove with this.
You produce a complete voters list of both the places.
Yes.
We'll put the question specifically to be decided by the tribunal.
And shifting also needs to be
That's
excluded.
that's right.
That part, lordship.
Complete list of both the places. Right. Heard Mr. A. Motin, Learned Counsel for the petitioner, also heard. No, now he is the father. Now, which document will show that
Yes.
that Habibur Rahman is the father?
My lord, page 33, my lord, school certificates.
This is again of a different village.
My lord, what happened in this case?
Goroimari. No, happened, many things happen. And many things may not happen. Both are equally
Yes.
possible.
During 1993, my lord, there is a communal rights in the Boroland, my lord. Her father Amtenga, my lord, set fire by the Boro extremists, my lord. That time, my lord, shifting in the Goraimari refugee camp, my lord.
Understand, how do you know? Where are those materials? The petitioner to produce all such relevant materials which may show that the family of Haran Ali, son of Tarifullah, whose name initially appeared in the voters list of 1966 of village Helengor Chor, had subsequently migrated to village Amtokatenga
Amtenga, yes.
so as to enable their names to appear in the voters list of 1989 of the said village. Full stop. Habibur Rahman, who is claimed to be the father of the petitioner, and Habibur Rahman is claimed to be the Habibur Rahman at serial 822 of the voters list of 89 is claimed to be the father of the petitioner, whereas Haran Ali at serial 816 is claimed to be the grandfather, where the voters list of 89 is available at page 24. To substantiate that, the petitioner Hasminara Begum is the daughter of Habibur Rahman. Reliance is placed on a school certificate of Nolonga High School, which contains the information that Hasminara Begum is the daughter of Habibur Rahman of village Goroimari. It appears that Habibur Rahman, after his name appeared in the voters list of 1989 at village Amtokatenga, subsequently again shifted to village Goroimari. Complete materials which may substantiate the shifting from Helengachor to Amtokatenga and thereafter to Goroimari be produced before the court. Further,
Education department may.
the education department to produce the admission register in origin of Nolonga High School for examination of the court. A copy of this order be made available to MSS Code, Learned Counsel for the Education Department. This constituency. You produce whatever you want to bring. The Election Commission may produce the upward and downward voters list of the two villages, namely Yes, Amteka Tenga and Helena,
Helenga's.
Item 7,
Nolong Tiba High School. Huh? Page number. Where is the school certificate? Page number?
School certificate is page 33. No longer high school.
No, he's asking for register of which period?
Ram Horis sir.
2019.
Admission registered
1993.
of the year 1991 to 93.
Class 8.
No,
Specifically, it's written.
date of
Lordship.
birth according to admission register is 1993. And left the school in the year 2006
Six.
from class 8. No, the admission register containing the admission of Hasmina Rabiga.
That-
Wherever it is there, you bring that. Here is difficult to find out.
Okay.
item 7,
My pleasure, Lordship. Lordship, we need some accommodation in the. Better maybe fix on Monday.
Lordship, I have received instructions as per the last order, Lordships. The court had directed to find out whether any ration card was issued in the name of.
Whether ration cards that were issued around the period 90 and later are still available with the authority. And if yes, whether ration card was issued Lal Mohan Das.
Yes, Lordships, I have received an
You
instruction
mentioned that
yesterday.
presently ration cards are issued and provision of it and database is maintained when.
No record has been found. Lordship.
Did she rely on the ration card?
No record of ration card being issued.
Lordships.
Going through the records relating beneficial ration card of Niece Dimoria maintained by FPH Manoj Das. No record of issuing ration card in the name of Lal Mohan Das.
What's it, can the matter may be taken on Monday?
Monday.
Yes,
Monday, something different will happen.
no, Lordship. My senior is.
Oh, your
doing
senior
this.
is not there. Pursuant to a earlier order of 19/6/2023, MS U Sharma, learned junior government advocate, has produced a communication from the inspector FCSNCA Kamrup Metro made to the Deputy Director Food and Civil Supplies and Consumer Affairs. Hey, again, FCSA. Which contains the information that as per the records maintained by the fair price shop dealer, Sri Manoj Das, there is no record of issuing any ration card in the name of Lal Mohan Das, son of Kailas Das of village Niece Dimoria. Mr. Chakma,
Lordship.
what's your complete name? SK.
SK Chak.
Mr. SK Chakma, learned counsel appearing for the petitioner, seeks for an adjournment to examine the aspect. List next thing. A copy of the communication from the departmental authorities kept on report. Thank you.
Leave the place.
item 8,
Okay, in this case, there is a shifting from village Kundanbari to Hettimari to. Petitioner has already collected the upline and downline voter list, but they haven't provided us the copy. We need some time.
You collected but copy not provided.
They have not given us the copy.
No, what do you mean by collected but copy not provided?
They inform
Your name?
J.A. Sikdar.
GS Sigdal, 6-point adjournment to produce the upward and downward voters list as indicated. Responsible.
item 9,
Your Lordship, my senior is on late. Can you pass over the matter for the time being?
item 10,
Which is your lordship? Lordship, total is of 1961 lordship, page 29. Darogali, he's a
Darogali. Who is Darogali?
father
Father,
of the petitioner.
Father Darogali. What is this top
61 lordship,
1961?
village Nararvita,
Nabar Vita. Okay.
lordship.
And who is the petitioner? Soila Khatun.
Koila Khatun lordship,
Which document will show?
lordship,
Soila
page 27 lordship, that is a Jamabandi copy lordship.
27. Jamabandi Nerar Vita.
Serial number 9 lordship, that is
Serial
Koila Khatun.
number, where is serial number 9?
Lordship, last part lordship, serial number 9.
Which one is serial number 9?
Lordship, page 27, 9.
Soila
Soila
Khatun. Okay.
Lordship,
Daragali.
lordship petitioner's brother,
Where
address
is
evidence, lordship.
Daragali?
One lordship,
Just a minute. Daragali is full of. Yes, Mr. Pine.
My lord, the Jamabandi copy itself, my lord, it is nowhere, my lord, there is no record in the Jamabandi copy that this land was owned by my lord Darakali prior to this. So I was looking for that, whether the noting is there. Because the my lord, the last order, first order. is
No,
of
the first serial number is of Darogali.
Darogali, my lord,
In his place, Soila Khatun has come
has
in.
been come.
So Darogali must be the name was in his name.
Yes,
So
my lord.
therefore,
My lord,
serial number 1, Darogali.
serial number 1 Darogali, my lord. That's
Hmm.
why I wanted to see, my lord, how the Darogali got and when did he got that land?
lordship, page 20.
That is not relevant for us. We are not deciding anything on the ownership of Darogali. This is not a dispute, civil dispute regarding ownership of land. This is a dispute only where there is an indication that this person had inherited the land of the other person.
Whether it is.
So that information is sufficient here.
And this document was not before the tribunal, my lord.
No, now let it go if it is there. Was the Jamabandi available in the record? No,
No,
this was later on collected.
This is later on collected.
It's a collected. Civil suit now, I know. Think of the money also doesn't know what they have. Yes, let it go back, examine. You find out whether this is a genuine Jamabandi or not. Verify from the office. If it is not, you place it before the tribunal that this is a fake Jamabandi. I heard was tasked in counsel for the petitioner also. This would be fine. The petitioner Soila Khatun had been referred to the
after page 52, lordship.
53. Had been referred to the Foreigners Tribunal number 2, Bongaigaon at Obhaipuri for rendering an opinion as to whether she is a foreigner under the Foreigners Act 1946, being aggrieved resulting in registration of FTT of case number BNGN stroke FT2A. This side of page 52, let's say. The tribunal rendered an opinion dated 11/1/2022 declaring the petition of a foreigner being aggrieved with writ petition is instituted in the writ proceeding. The petitioner relies upon, where is that voters list of Darogali?
Lordship, page 29, Lordship,
29.
29.
Relies upon the voters list of 1966 of village,
Lordship, 61.
61 of village Norar Bhita, which contains a name of Darogali, son of Kasem Ali, at serial 843. And it is claimed that Darogali is the father of the petitioner. To substantiate that Darogali is the father, reliance is placed on a Jamamandi of a plot of land at village Nadar Bhita, wherein which has a reference to an order of the circle officer dated 29/5/2017 in mutation case number BON SRI stroke 2016 stroke 1 stroke 13 stroke MUI. By which, in respect of DAG number 169, land had been mutated, amongst others, in the name of Soila Khatun, daughter of Darogali, in place of Darogali. The Jamabandi also contains information at also contains a name of Darogali at serial number 1, whereas at serial number 9, upon being mutated, the name of Soila Khatun had been added in place of Darogali. We have therefore remanded back to examine the voters list of as well as the Jamabandi and pass a reasoned order. The respondents in the Home Department may verify on the authenticity and acceptability of the Jamabandi referred above and submit a report before the tribunal.
Only one line, your lordship, as this was not earlier.
As the Jamabandi was not placed on record earlier, the respondents may make a thorough verification of the said document and submit before report before the tribunal. The petitioner to produce the complete voters list of 1961 onwards of village Narar Bhita to substantiate their claim, more particularly in respect of the other persons whose names were also mutated in place of Darogali, and whether the names of such persons are available in the subsequent voters lists of village Narar Bhita. Find out that also. Because you see,
Yes.
in
5,
place
6.
of Darogali, Mazu Sheikh, Mion Ali, their names were also mutated.
Name appear, Lordship.
So, if the name of Mazu Sheikh and Mion does not appear along with Darogali in any subsequent list, it may be something
Lordship,
upon doing the needful a reason order because.
yes, Lordship.
Item
The
11,
respondents to also verify whether Soila Khatun, the writ petitioner proceedee, and Soila Khatun, whose name was mutated in the Jamabandi, are also one and the same person.
Yes, Lordship.
May I please? My lord, in this case, my lord, last occasion, my lord directed me to produce some documents regarding shifting, my lord. From village Kismat Manbari to village Kasdoha, my lord. I could not find out till now, my lord, more time is required, my lord. Kindly give more time, my lord.
You want time? By the order of 22/5/2023, by which notice was issued, there was also a requirement for the petitioner to prove that the family of Asuruddin had shifted from village Kismat Manbari to village Kasdoha. Your name?
M. Hussain, my lord.
Mr. M. Hussain and county petitioner seeks for an adjournment to provide such information.
Most of them.
Item number 11, Lordship, in item number 11, it was directed to file a registered case before the local police station Behula Khatun.
11.
Behula Khatun.
Behula Khatun.
Behula Khatun রয়েছে?
Yes, Behula Khatun.
Oh.
27.
Right, you can go on this. Just check up. I don't think it will
Select Behula.
It's a requirement of some other matter.
No, no,
Sorry.
it is not the case, madam.
Some other
Name-
matter.
Name is
Actually,
same, madam.
name
but-
same Lordship.
Okay.
Sorry, Lordship.
Most of them.
So have you understood? You people always take the help of the name. That is the name and this is my name, so I am the same person. It is happening before the court that there are two different petitioners also having the same name.
Yes, madam. There are numbers,
So,
not only two.
yes, Mr. Sikdar. Normally, when you question that, you always try to oppose it. That yes, that name is there. So this is a glaring example that same name, there may be many more number of people.
Petition. Yes, ma'am. That may be. There are numbers, my lord. I have.
Yes, so next item 12, who is appearing? AMS Mojumdar.
Item 12,
None appears for the petitioner when the matter is called, list again in the event of. No, record to IPO 9. Record 9, no? It is noticed that the records have not been received, registered to issue reminders. List again. And none appears for the petitioner.
item 13,
Jamila Khatun.
I mean, petitioner already expired.
So,
Maybe close, my lord.
Jamila.
I mean,
Jamila Khatun.
yes,
Jamila Khatun.
Mr. Who are you?
Abdul Motin Ahmed. Elias Ayumuddin.
Mr. Abdul Motin Ahmed, land counsel for the petitioner, had made a statement that during the pendency of the writ petition, the writ petitioner died on any idea?
Yesterday night, I have to get instruction from the. advocate, my lord.
Died in the meantime. Accordingly, it is submitted that no further adjudication is required. Writ petition accordingly stands closed. The records received be sent back to the.
Publish.
item 15,
May please, your lordship. My lord, here in this case, my lord, 65 brutalist lordship will find at
Page
page,
number
page 25.
25. Village
Village
Maleka Dhing,
Father Amsar Ali.
Amsar Ali, serial
Sakina.
257.
Yes, my lord.
Page number
My lord, page, this is page 25.
25. Amsar Ali, yes, he is the father.
Amsar Ali is the father. Then, my lord,
Now,
70 brutalist lordship
we-
will find at page 27,
no,
Amsar
that
Ali.
is-
Then, my lord,
which document
29.
will show that
29 brutal, 29, my lord.
page 29.
93 brutalist. Amsar Ali is at 406 and my name,
Sirajul,
407. Sirajul.
407.
Yes, my lord. A part of that, my lord, Jamabandi copy is also there.
Where is the Jamabandi?
Lordship will find Jamabandi copy. At page 62.
Page
62.
62.
Vernacular at page 63. So order under Kho, চক্রবিকার সরজমিন চিঠার 1/98 তারিখ হুকুম মতে পট্টার
Sirajul, son of Amsar,
Yes,
this Maleka Dhing.
yes, my lord. আমসারর উত্তরাধিকারী সূত্রে আমসার আলীর স্থলত সমর আলী শফির মোহাম্মদ সিরাজুল জয়গুন রুকিয়া সুফিয়া খাতুনের নাম নামজারি হয় Vernacular at page 63.
Yes, Mr. Pang, what do you say?
Very clear case, madam.
Clear case.
No, my lord.
What do you say, Mr. Pang?
My lord, exhibit 5.
Have you noticed the last submission? Have you noticed the last submission of Mr. Sikdar?
Yes, my lord.
He says it is a clear case.
One of the brother was also examined.
93 footer list, my lord, it is, name is there. Sirajul is.
Jamabandi also it is there.
Jamabandi was probably not exhibited.
Executed.
Please, ma'am, Jamabandi.
What do you do? We finish it here only?
Please, see, ma'am.
Hmm.
Jamabandi was not, the 59 was. It was, Jamabandi was not exhibited.
Do you doubt the genuinity of the Jamabandi?
Let it go for cross-examination of the Jamabandi at least.
How will you cross-examine the Jamabandi?
Now, with regard to the authenticity and,
No, how will you cross-examine the Jamabandi?
no, with regard to the, my lord, the authenticity of the Jamabandi,
Whom will you cross-examine?
the circle of ceremony.
Why will the circle officer come? Circle officer has many other duties to do. Why should he keep sitting in a tribunal? Your police can make a verification from the office whether it was genuinely issued or it was not issued. That we can do it.
Let it be done by the police.
Very fine.
My lord, 89 brutal is also there at page
Everything is there.
59.
89.
In
was-
other words, Mr. Paying, if the materials are overwhelmingly in favor of the petitioner, why should he not finish it here only?
Understood, my lord. Even 89 voter list was also not exhibited there, my lord.
Why don't you exhibit all the documents if it is there in your
Yes,
favor? But Mr. Riyashidal and counsel. Phone.
Incident not caused by us. Sirajul is money to short of this. Buza kotha mile kiyam buza ke unnecessary kiyam money.
Electronically generated.
Ako bill zero kate ko. Order the harassment convention.
Mr. Pine, Mr. Pine, I was asking, why don't you finish it here only?
As your lordship.
Because this is, see, it's an electronically generated Jamabandi. This is possibly covered by section 65B of the Evidence Act. Unless you have material to say that, no, this is a fabricated document.
I cannot say, my lord, without verification.
That's why. Or you can adjourn it for today. You tell us, obtain your information, whether this is fabricated or not. Because under the Evidence Act, this is admissible. You see, admissible under the Evidence Act.
And this is admissible as per evidence.
So only opportunity we can give you. If you want to submit a report before the court, we can allow you to do that.
Let me give 2 weeks, my lord. I'll give.
Mr. J. Paying, Land Counsel for the Home Department, seeks to obtain a verification report from the Superintendent of Police border of which district?
My lord, it's Nagaon district.
Of Nagaon district on the authenticity and acceptability of the Jamabandi available at page 63 and except 13 to the writ petition. The report be submitted before the next returnable date in this council.
Deeply obliged.
Item 15,
Update करें. Display update one. Display one. Problem.
Wait, listen. My lord, in this case, notice was issued, my lord, by an order dated 24/5/2023. My lord. I have to file affidavit, my lord, uncorrupting some documents to show that the petitioner father was earlier in Mohanpur village, my lord. But I have, that means the petitioner has collected some documents, but those documents are not enough, my lord. Some
The
other-
petitioner, your name, Talukdar?
MS.
Mr. M.H. Talukdar, legal petitioner seeks for an adjournment to provide further materials regarding the shifting of the family of Monser Ali from village
Mohanpur part
293-5 number Chor to Mohanpur Part 2 as required by the order of 24/5/2023.
Lordship.
Prayer allowed, listen on so and so.
Item 16.
Yes. Yes.
My lord, father name is Baksha Ali and mother name is Nalbhanu, page 60. Total is 66, my lord, page 18. 18, 19, page 20. Are same, my lord, but same village, my lord. And her name is appear in the voter list of 2008, page 23.
Same village.
Please. Page 18 of 23.
So Surya Banu after marriage is living with her father only?
Yes, yes.
Yes, that's a fine. That is- How many Surya Bhanus are there?
Suryabanu, one is the sister-in-law, wife of Jamal,
Wife of Jamal.
Yes.
Jamal is the son of Badshah.
Baksha.
She is also Surya Banu.
Yes.
And the daughter is also Surya Banu. And the daughter is also living with the father.
Yes, my lord. House number 197.
Yes, Mr. Pai, what did you do?
Joint family.
92nd Suryabanu is there, my lord, page 22.
Mhm. Huh.
And 93.
Against which Uddhav Saluk.
This is Kuddus Ali, Santospur, same village. Kuddus
Same
Ali is the husband.
Husband.
Of Santospur.
Huh. Even after marriage, Surya Bhanu is staying with her father and Kuddus Ali is staying with her.
Mother reduced evidence. Mother. Nalbhanu. Page 59, my lord, first part.
Mr. Pai, you verify, that's the only way out.
Yes, ma'am.
Ask the police to go verify in the family, find out what is happening. Otherwise, we are neither here nor there.
Let me verify.
You go back. Or here only. If you want to verify, submit report before us, you can do that.
Better go there, my lord, because it's overburdened on us. My lord. Verification.
And Mr. This time, your name? Hmm.
Abdul Motin Ahmed.
Heard Mr. Abdul Motin Ahmed and counsel for the petitioner also heard. The petitioner Surya Bhanu was referred to the foreigners tribunal number.
Second, Bongaigaon.
Foreigners tribunal number 2, Bongaigaon at Abhayapuri, for rendering an opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of B and G and bracket 2, stroke APR, FT case number 847 stroke 2017. Tribunal rendered an opinion dated
23/12/2023.
2022, declaring the petitioner to be a foreigner being aggrieved. The said petition is instituted. In the proceeding, the petitioner relies upon the voters list of 1966 of village Santoshpur 3, police station, Uttar Halmara, in the present Bongaigaon district, which contains the name of Badshah Ali, son of Tahir, at serial 166, and that of Sokina Bewa, wife of Tahir, at serial 167, and Nal Bhanu, wife of Badshah, at serial 168. It is claimed that Badshah Ali is the father, Sokina Bewa is the grandmother, and Nal Bhanu is the mother of the petitioner. Similar information is also available in the voters list of 1970 of village Santoshpur Part 3. Petitioner thereupon relies upon the voters list of
2008. Page 23.
just a minute. This is Nal Bhanu or Lal Bhanu? I think Lal Bhanu. Yeah, it also contains the 1985 voters list of village Santoshpur. Part 3 contains the name of Badshah Ali, son of Tahir, at serial 434, and that of Lal Bhanu, wife of Badshah, at 435. It also contains the name of Jamaluddin, son of Badshah Ali, at serial 436, and that of Surya Bhanu, wife of Jamal, at 437. The voters list of 2008 of village Santoshpur Part 3 contains the name of Badshah Mia, son of Tahir Ali, Lal Bhanu, wife of Badshah, Jamaluddin, son of Badshah, and Surya Bhanu, wife of Jamaluddin, along with Surya Bhanu, wife of Quddus Ali, and Quddus Ali, son of Qadir, respectively, at serial number 911, 912, 913, 914, 915, and 916. It is claimed that Surya Bhanu, wife of Quddus Ali, is the writ petitioner, who even after her marriage continued to live along with her father Badshah Mia. And it is also explained that Surya Bhanu, wife of Jamaluddin, is the sister-in-law of Surya Bhanu, wife of Quddus Ali. Any further document? No.
Others, my lord, voter list of 2011 also, my page 24, 25.
The voters list of 2011 of Santoshpur Part 3 also contains similar information. We are remanded back to the tribunal to examine the voters list of 1966, 1970, 1977, 1985, 1997, 2008 of village Santoshpur Part 3, and the petitioner shall produce the complete voters list of the aforesaid years before the tribunal for its examination. The respondents in the Home Department to make their own verification in the house of Badshah Mia as to whether the factual depiction that Surya Bhanu, wife of Kudus Ali, is the daughter of Badshah Ali is the correct information, and thereafter submit a report to the tribunal. The respondents to also verify as to whether the writ petitioner proceeded Surya Bhanu and Surya Bhanu at serial 915 of the voters list of 2008 of village Santoshpur Part 3 are one and the same person upon being the needful.
Item 17,
Please, Lordship, and it is matter, maybe adjourned.
Adjourned
Yes, Lordship.
for that day.
Yes, that's what
Adjourned on the prayer, Mr. S.K. Chapman and counsel for the petition.
item 18,
May I please, your Lordship, my lord. My lord, the voter list of 1966 of father and grandfather together, my lord, page 25, my lord.
Page number 60,
Page number 25, my lord.
25.
My lord. Grandfather is Daulat Sheikh, my lord. And father is A. Motleb, my lord. Abdul Motleb.
Daulat Sheikh grandfather, Motleb father.
My
No.
lord. And the, my lord, the voter list of 1993, page 31, my lord.
Page 31.
The name of my lord petitioner appears, my lord, as Abdul Qadir, my lord. Abdul Qadir is the petitioner, serial number 647,
Yes, sir. Page number 31.
my lord.
Abdul Qadir, he is
He is the petitioner, my lord.
petitioner.
Yes. Along with his, my lord, younger brother Hassan Ali, my lord, serial number 649, my lord. He had also deposed before the concerned tribunal, my lord. The younger brother.
What about Abdul Qadir? What about Sukhia Khatun? They have died.
Sufia Khatun is the mother, my lord.
Uh,
So stepmother, my lord, and Kulsuma is their Khatun is the own mother, my lord.
no, own and step we understand, but what happened to Sukhia and Motleb?
In the voter list of 1970, my lord, the
In
name of
the 1993, what happened to them?
the death instruction is not there.
Get the
Probably they
information.
know.
Otherwise, they know what to have been there. Hmm.
But in the voter list of 77, my lord, their names are there, my lord. Page 29, my lord. Page 29, my lord, voter list of 77.
Hmm.
There, my lord, the name of the stepmother and the own mother is there, my lord. Sufia Khatun and Kulsum.
In 70 also it is there, page 27.
Yes, 70, my lord, I had referred. 70 is also there.
'77 also it is there. Yes, Mr. Pine. '60 Motleb is there.
Yes.
70 Motleb along with Sufia Khatun and Kulsum Khatun, two wives. 77 also two wives and Motleb.
In the petitioner's name appears, my lord, nobody of that family is here.
Only Kulsum is there.
Kulsum is there, my lord.
Kulsuma Khatun.
Page 31, 93.
Yes.
Kulsum is there.
Kulsum is she's the mother, my lord.
Kulsuma Khatun here is, my lord,
Mother.
is wife of Abdul, my lord.
Abdul Motleb.
Abdul Motleb.
Yes. And
And he is Abdul Matlab only, A Matlab.
Abdul Matlab, and age is 37 in my lord.
That
90.
discrepancy is
What is your age in your voters list?
My lord.
Mhm. Age is almost no relevance in a voters list. It's only a figure that is required to be put, so they put it. Sometimes it is, we can find out something, but Kulsuma in 1997 is 45 years. 1977, in 1993, she is 37 years. Why?
That's why, ma'am.
that discrepancy is there, ma'am. Age discrepancy is there.
So what is to be done?
She was 45 in 77, my lord.
Hmm.
Yes, ma'am. But in 1993, her age became, my lord, 37 years.
Hmm.
The discrepancy is
47, 45 in 97
Hmm.
and 38 in 1970. 34.
34 is there.
So that
70.
consistency is there, but how can it come down to 37?
That
What about 85? Let us see.
85 is not there with me.
Bring 85.
My lord, my lord.
It is noticed that. Oh, wait a minute. Okay. This is only a thing. Hmm. No, no, no. Hey, kerosene not good guys. Some of it. No, no, it's even like it. Kerosene must be independent. This is why it's good to do it. Someone getting over so well. Yeah, it's good to hear. Mana শুনলো না মই এবার আশা করছি এই চিমনি যেটা উঠাই দিব কেন নাহলে নহব কাম এবার মাথা মনে করা নাই বুঝে কেরোসিন লেন দিতে বন্ধ রুমে তা দেবো Yes, sir.
My lord, the name of the petitioner, my lord.
The petitioner to produce the voters list of 1985 of village
Utkati.
Udkati to verify the age of Kulsuma Khatun, wife of A. Matlab.
Right.
In a circumstance where the 1977 voters list shows her age to be 45 years, the 1970 voters list shows her age to be 34 years, whereas the 1993 voters list shows her age to be 37 years.
Lord,
85 will be clear, my lord, because if 85 voter list is there, the petitioner name should have been there in 85. ma'am.
Let's check that it is.
Because he was 18 years in 1976.
Item 54 for hearing.
my lord, in this case, my lord, I produced a Jamandi copy, Dharitri copy. And lordship has asked for report of this.
Page number.
My lord, in affidavit, my lord, it is page 70,
70.
72, my lord. Vernacular at is 73. But subsequently, I got
Page 70, what is it?
my lord,
Page 70 is a part of some additional affidavit.
Yes, my lord. Additional affidavit.
Hmm.
Additional and affidavit enclosing a Jomati in Doritri copy, my lord.
You are relying on Jamabandi.
Jomati.
Where is the Jamabandi?
My lord,
73.
Annexure 17,
Page 73.
73, my lord.
Soravali,
Surabali,
Pita Kurpanali,
Kurbanali,
Sarkar.
and
And
Daliman Nasa.
petitioner is Dalimon Nesa, Pita Soravali.
Surabali.
This is of village Ram Horir Shor
Sure.
Trityo Khondo.
Yes, my lord.
Where is the name of Soravali in any acceptable voter's list?
My lord, will find in 66 voter list,
Page number.
page 26. my lord. Soravali, Kurbanali. Same village, my lord. 70 voter list also.
Page number, which page number you say?
70 voter list at page
No,
28.
66 at page.
66, my lord, at page 26, my lord.
26.
Translated copy, page 25.
Yes, yes, son of Kurpanali. It is Ramadi for Trityo Khondo. Ramadi for Trityo Khondo, Soravali, Kurpanali, Pahina Dalimon Narigal, Soravali, son of Kurpanali. Ramadi for. Yes, Mr. Pine.
My lord, the Jamabandi copy here produced, page 70. My lord. The father, when father is alive, my lord, Surhab Ali is shown to be alive. When father is alive, my lord, her name cannot come in, my lord, on the basis of, my lord, the waris.
Waris is even lifetime, my lord, father can give, my lord. So waris,
Inheritance cannot be done, my lord, when the father is alive.
Where is the law? Where is the law that there is no inheritance when father is alive?
But inheritance of land, my lord, land revenue
No,
regulation.
where is that law? Then the inheritance may be unacceptable in law, but that will not take away the fact that Dalimon Nesa is the daughter of Soravali. See, we are saying it repeatedly. We are not in a civil suit jurisdiction to determine the entitlement of land of anybody.
And
These information are taken as corollary information to indicate who is the father and who is the son or daughter. That's all.
but why I understood, my lord. Only point is that, my lord, this Namjari is done much after the, my lord, the
Understand?
recorded, the case is registered.
So
and-
only way out for you now is, this is a order on record. We cannot ignore it. Only way out for you is to make a verification, submit a report. If you bring in any semblance of a material that yes, we have verified. Our verification reports shows that this information is incorrect. We'll definitely go into it. But minus that information before the court, we just can't ignore relevant documents. And these are all electronically generated from that official website, Dharitri. There is a possibility that this information in the Jamabandi is right, but the circle officer had wrongly mutated, taking note of incorrect facts. Then you have to make an inquiry. Number one. Number two, you can also challenge this order, that this is the fraudulent mutation order. You can always do it. But without that minimum effort, we can't reject these materials. Your apprehension is maybe right also. We are not saying that you were wrong. But the method to be adopted will be a little different.
Let it be, my lord, then let us verify it, my
You
lord,
verify here or
in the tribunal, man.
tribunal. Okay, fine. If you want, we can adjourn it also so that your report comes.
Then let me try, my lord,
You want to adjourn?
yes.
Mr. J. Paying, Land Counsel for the Home Department, submits that the department intends to make a verification on the authenticity of the information contained in the order of the circle officer dated 31/10/2019 in mutation case number GOA/BAL/201/20/278/FMUT as depicted in the Jamabandi at page 73, annexes 17 to the writ petition. Because one aspect is there, Mr. Pine. All these mutation orders takes place after the proceedings start.
Yes, my lord, even after declaration, he
Ah.
has to be a foreigner, man.
So.
He has been declared foreigner in
But
2018.
only way out for you is to make a verification, bring it to the notice of the circle officer that these are all wrong informations that had been given and are obtained. So cancel the mutation order.
My lord,
Once you undertake that exercise and bring it to a record before this court, we'll take note of it. We'll not rely on this information then. But till that minimum step is undertaken,
we have to accept it.
we have to accept it. কি করলো? হয়ে গেল না? Complete, huh?
After
List after 2 weeks for the verification report by the Home Department.
develop.
Item 55,
Please, your lordship.
But otherwise, Mr. Pine, this Jamabandi is admissible in evidence
Yes, my lord.
because these are electronically generated documents. They are covered by section 65B of the Evidence Act, I think.
My lord, only my point was that because the person was declared foreigner prior to that. Whether this fact was, my lord, disclosed there or not,
No.
probably these things were not.
If you do it, then you
Yes.
put up an application before the circle officer that factually incorrect order had been passed
Because
to be.
her name was, she was declared foreigner only because she could not establish herself, her link to her parent, my lord.
Mhm.
So on what basis? He
No,
has recorded.
no. Circle officer jurisdiction is different.
No, that's why.
He
whether
will
he has-
only go by the applications made, objections raised or otherwise.
Yes,
That's
so it is on the basis of their application.
But circle officer, no duty is entrusted
Yes.
to go to house and make all kind of. That is for you to do. He can always make an inquiry.
That's good.
Circle officer. His lordship pointing out there will be a report of the Mandal also.
Yes.
For the circle officer. Verify those things.
There should be a report of Mandal,
Huh.
then my lord, on what basis?
So you send your policeman and get it verified. Let a police go to the office of the circle officer, give me the records
That's
of
why
the
I-
entire mutation case.
That's why
I want
I
to
asked for
verify.
the, my lord, details order, the mutation order itself. Mutation order.
No,
everything is
you
there.
cannot ask. You have to provide.
Yes,
If you want to rely. Huh? You sent your man,
Yes.
procure it, bring it for us.
Item number 55, my lord. There are some records of school register, my
If
lord.
we examine the admission register in Oregon.
It is there, my lord, because my learned friend has missed, my lord, today the item, so record could not be brought. Record is with
Okay. Bideka.
Yes.
No, lordship, in
As
this matter,
one.
as per.
as one. Satyavati.
You are S1.
No,
No, I'm,
It
You are
is
Bideka.
on-
Huh.
no, this matter is looked after by as per.
It is with her, my lord.
Hey, it's up to you. MSB Deka, Land Council Education Department, raised for the adjournment to provide the admission register in original as indicated in the order 23-6.
Item 56.
That matters. 302, whether a,
Yes.
you'll need a detailed hearing. Because possibly this issue has not gone into.
What I find, Lordship, in fact, some observation from the court would be necessary because they are guided by their manual.
Hmm,
Manual as it is, the whatever is there has been
That is the
complied.
manual.
If I may please.
See, otherwise,
And it is just like a
No.
jury system.
no. I'm trying to give a little different example.
Flush.
You want to go for a complicated open heart surgery. A doctor can perform.
Expert.
No, a doctor can perform. That's the only requirement.
Yes.
Expert comes later on. That you have to adopt the expertise required for doing an open heart surgery, and only the doctor who is also called a surgeon, who is having this qualification, who is having this experience alone is otherwise ought to do it. But any doctor can also do it. I'm a doctor. Where is the prohibition in the medical ethics? There is no prohibition. Similarly, when it is a matter of trial of a 302 case, where the law relating to 302 can be found in multiple volumes also of books. So that means the law is that complicated.
Yes.
The principles are up to that extent. Does a officer of the armed forces who may be having a law degree also, we don't know, or may not be having also, but he is either a commandant or a very, very senior officer. How does he derive the competence to decide this issue? Because 302 is not just one person killing another person. Had the law been as simple as that, if X kills Y, X is liable under 302. Very well. You don't need any judge also possibly to decide that. Just find out from the material whether X has killed Y or not.
Sufficient.
Sufficient. There, had it been a full stop, it's okay. But there are many other aspects. 302, 304, then these, that, then self-defense, then grave provocation,
Yeah.
circumstance, so many aspects.
And in fact, Lordship,
How do you expect this respected officer of the armed forces to give a correct verdict on the 302? On his service side, we are not expressing any view. It is absolutely your call. A man killing another man, we don't want him in the inner service. It is your call. You dismiss him, you do whatever you do with him. That will consider it separately. But to convict him under 302
yes.
and retain that conviction, will Article 21 not be violated? If you examine from Article 21 point of view, forget about your manuals and
Yes.
everything else. Will that same officer, if the necessity arises to for a open heart surgery, will subject his heart to be operated by any doctor?
Definitely.
Go to the neighborhood government dispensary, yes, open my heart. Do the needful. If he is not ready to face that, why will this man be ready to face a conviction for 302 to be decided by?
I do get your Lordship. That is
So how do you decide now? First, let us fix the modalities in which, how will you proceed in this matter?
Lordships. And more interestingly, my lord.
No, because I don't think you'll find any precedent. You'll not find
Yes.
anything else.
Is what we have discussed, my lord.
So how do you determine the modalities in which to proceed in this matter? How to proceed in this matter?
And more interestingly, my lord, what happened in this case, the conviction was given under the process of disciplinary proceedings, my lord. They have initiated disciplinary proceedings and disciplinary proceedings, my lord, they have convicted me.
No, I think it's a inseparable.
Because
It's a court, I think it's a court martial proceeding after all. Is it court martial or what? Court martial.
Yeah, court martial not exactly said, my lord.
Court martial.
Where is the initial notice? Let us see.
Initial notice.
Initial notice of issuing the proceedings, initiating the proceeding.
Here, my lord, that
He's a man of which service? Army or
my lord, BSF.
BSF?
My lord.
So BSF court martial must be called General Security
Yes.
Court.
My lord.
It's equivalent to court martial in the army.
My lord, yes.
So comes to same thing.
My lord.
Where is the initial notice
Initial
of
notice,
initiating the proceeding?
my lord, yeah. Page 20.
Initially, the proceedings were before the, it's not the criminal court.
I know,
But then
we have already gone through it. There, one officer comes and makes a statement possibly.
Hmm.
Let this proceeding be conducted, and the court also said, yes, let it go. And
Yes.
criminal court also never applied its mind on this question. Criminal court could have refused it. Or put that question, how will you decide or who will decide?
Initially, my lord, after his close arrest, my lord.
No, where's the first notice, page number?
Notice
No. Before the proceeding was initiated by this, what it is called, General Security Force Court,
my lord.
there must have been a show-cause notice or something like that?
Yes, my lord, after FIR, he was close arrest, then staff court of inquiry was conducted. After his staff court of inquiry, my lord, it was sent to the, my lord, GSF, my lord, General Security Force Court.
So there
That
is no
means-
notice. How you are aware of the charges against you? Or how you are aware of the allegations against you?
It was, my lord,
See, normally, when there is a disciplinary proceeding, there is a section 9 show-cause notice
my lord, yes.
where the charges are stated, the allegations are stated. Then the delinquent knows what to defend. In this case, a similar procedure was not followed.
My lord, yes.
Then how the accused is supposed to know what he is to defend?
Here, my lord, what happened? Initially, they have lodged an FIR. Thereafter, as per procedure, he was close arrest. That is-
If the FIR is lodged and there is an investigation under the CRPC by any authority or any authority for having the power of say under the CRPC, and a charge sheet is submitted before the competent
My
court,
lord.
we understand.
Mhm.
There is no difficulty with that. But if an FIR is lodged, where is the power given to the BSF authorities to investigate that FIR?
My lord, yes. It was.
Is any power available? Or else we have to understand that that FIR was never investigated. Where is the FIR? Let us see.
At page, my lord, 19,
19, 19.
19.
To the SHO PS Satakaha, Juneboto. So he is OC of a police station.
My lord, yes.
So CRPC comes out. FIR is under 154.
My lord, yes. FIR is under.
So if we consider this document to be an FIR under 164, 154. What will the police do? Every information relating to commission given orally so and so that they shall be signed by the person giving substance thereof shall be entered in the book to be kept by the officer. Provided a copy of the information if any person agreed by the refusal. So this is 154. 156, police officers power to investigate cognizance. Any officer in charge may, without order of the magistrate, investigate cognizance having jurisdiction. So once it is a FIR under 154, next step is 156. How can the BSF authorities assert that power of 156? Is there any such provision in the BSF Act? BSF Act comes out
My lord, at page, my lord, 46, section 46, my lord.
of the BSF Act.
My lord,
Let
yes,
us
civil
see.
offense.
Civil offense means criminal offense.
My lord,
That
yes,
is their
yes.
definition. We have
Yes.
read it. It's a very
Yes.
peculiar definition. Civil offense
Yes.
also includes criminal offense.
Yes. Yes. And also section 80, my lord.
That
46.
we have read. But where is the provision under the BSF Act by which the authorities under the BSF will exercise the power under 156? Unless you exercise the power under 156, a FIR making out a criminal of cognizable criminal offense cannot be taken any further.
My lord.
Force court will be a forum where the trial will take place.
My lord.
But before a trial takes place, there has to be investigation, there has to be a charge sheet.
My lord.
In what manner it was investigated, in what manner charge sheet filed, by whom, and by exercising which power
It is staff court of inquiry, my lord. At page 21, your lordship may see.
of this BSF Act?
No, my lord, in my petitions, my lord. At page 21, annexure 3.
As approved by the competent authority with the DIG is detailed to conduct one-man SCOI. What is
Staff
that?
court of inquiry.
SC to investigate in the circumstance under the fire even rounds of the. Yes, you can do this staff court of inquiry for the purpose of taking any disciplinary action against this man.
No, this staff court of inquiry is only for the purpose of ascertaining the facts.
What may
What
have
had
happened.
That is a court of inquiry.
That's why I say purpose is to take disciplinary action against a
That
person.
is the subsequent.
Subsequently, if you find that
Yes.
the preliminary inquiry reveals his involvement in some unacceptable act.
Yes.
But at what stage these proceedings are converted to a proceeding under 156 CRPC? And let us read section 4 of the CRPC.
Section 4.
You want a CRPC?
No, I'm asked for the record. Is there?
CRPC you have with you?
I'm asked.
CRPC on the I say both you have CRPC.
My lord, one more documents I have found.
No, we'll go to documents. Let us go step by step. We come to section 4. All offences under the Indian Penal Code shall be investigated, inquired into, tried, and otherwise dealt with in accordance to the provisions hereinafter contained. So this is regarding IPC. Subsection 2 is regarding any other offences under any other act. It's nothing beyond that. All offences under any other law shall be investigated. So that means those Arms Act, this Act, all. So they are also investigated under the CRPC. But is there any exception that an offence under IPC can be investigated by somebody else?
It has to be in the other act. It has to be in the BSF Act.
Can the BSF Act have an overriding effect over the CRPC in respect of investigation of a criminal offence? Now let us read the BSF Act, which is the most closest of the relevant section.
It will be the particular section regarding savings and
Savings,
repeats.
BSF Act.
I just try to find, normally it is there in all acts. Overriding effects.
Let us see.
I'll try to find out.
My lord, rule 41, my lord.
No, BSF Act overriding effect. It is not the repeal and savings. Manner of proceeding against under section, extent of punishment, the procedure of court of inquiry petitions.
Six, 43, 44.
Investigation of.
Offences. Come to chapter 3 of the BSF Act, offences. 14 is offence in relation to the enemy and punishable with death. Offences in relation to enemy not punishable with death. Offences punishable more severely on active duty than at other times. Mutiny, desertion, absence without leave, striking or threatening superior officers, disobedience to superior officer, insubordination, false answers, certain forms and disgraceful conduct, ill-treating a subordinate, intoxication, permitting escape of person in custody, irregularity in conducting with arrest, escape from custody, offences in respect of property, extortion and corruption, making away with equipment, injury to property, false accusation, falsifying documents, signing blank, failure to report, offences related to security force code.
Lordship, subject to,
Hmm,
Lordship, may I take your Lordship to Rule 41?
Civil offences, huh?
May-
Section 46 is civil offences. Page 16. Subject to provisions, any person subject to this act where any civil offense shall be deemed to be guilty of an offense and you charge them with it.
Charges.
May I take your Lordship to Rule 41? please?
It procedure.
Rule?
Rule 41 of the Rules 1969, if your Lordship is having this book, page 61,
Color appears to be same.
page 61.
Okay. Civil offense means an offense which is triable by a criminal court.
The definition is a bit,
No, civil offense triable by a criminal court.
so
All offenses. Again, 47 throws some light, section 47.
Lordship.
A person subjected to this act who commits an offense of murder or corporal offense is rape in relation to a person not subject to this act. But here the other person is also subject to this act.
Yes.
So 47 will not be applicable. The man who was killed is also a BSF man.
Yes.
Criminal court means a court of ordinary criminal justice in any part of India.
If we go by the definition, Lordship, any criminal offense as per this act is a civil offense.
In any other case, Trial of cases, prosecuting judges are duly qualified. Now, who had conducted this trial?
It was.
He's a regular senior officer or
He has a DIG.
DIG? Does he have any law degree? Firstly, does he have any law degree? If he has any law degree, is he trained?
Because he may not be having a law degree, but
So the,
officer guys, it's
so the initial question,
yes,
whether you subject your heart
that's
to a person who even is not a MBBS also.
That's this.
Hmm.
And this
No, it is permissible, no doubt, but can't we examine it from the point of view of Article 21 of the Constitution?
worship definitely.
Hmm. Constitution. No? Hmm. Hmm. His Lordship is pointing out 21, there is a provision that the trial must be a fair trial.
Yes.
And the fair trial also requires that the judge must be qualified, eligible to try it.
Here, simple graduate.
That principle really hit this person. We don't say you cannot do it, you do it.
But with a
But
qualified.
to do that, you also have to put in place a person who is duly qualified for that purpose. And and he alone can conduct a trial under 302, not anybody else. Your force code doesn't mean that this particular DIG alone has to be there.
No, there are 5 persons.
Maybe 5, but 5 incompetent person doesn't make them wholly competent. That their accumulation of the 5 incompetencies will result in a competency. That is,
I agree
there
with
is
you.
no such principle.
Here, from what I have seen from those manuals, it's a decision by a majority. When it's a decision by a majority.
See, earlier jury system was there, but only the view of a jury system was taken. Jury system did not ultimately result in the order. Order was always passed by a judicial authority. The earlier jury system that was prevailing in the pre-independence period, the judicial authority will take the view of the juries.
Yes.
But it is the decision of the judicial authority. So even if you term these 5 vice persons to be in the nature of a jury, there can be only recommendatory in nature. But the decision has to be by a judicial authority. Then possibly the entire thing will be that at the stage when they come, that we have sufficient material before us, the matter should be transmitted to a regular criminal court to give a verdict.
Flush.
If necessary, take more evidence if it was not followed.
Yes.
Think over it.
Yes.
We'll hear you because this is a very
Lordship, it needs some interpretation.
And that's what we are
I'll be
thinking.
very fair. But this perhaps is,
When do you want? We'll have it. Are you completely prepared
My lord, yes.
for answering all the questions?
Regarding these issues, my lord, I am not prepared because
On
the
this
question
issue,
which was before raised before this honorable court,
Ah.
my lord, yes. It's a research work, my lord. Interpretation is
are
very
you
complex.
wholly prepared?
No, my lord.
When do
Regarding this point,
when do you want to be heard?
my lord, keep in mind.
Get a fixed date, we'll
My
hear
lord,
you on
yes.
that day.
थोड़ा काटना, विधानसभा में था। Ready to move on, I will.
second week of, first week of November.
और अब फिर side of defend.
But otherwise, don't you think it is a little incoherent?
Lordship, I'm on camera.
Hmm,
I'm on camera, Lordship.
I know, but still,
Lordship, that is why I say Lordship, it needs some interpretation. Lordship.
similarly, take any number of examples. You are not ready to give your open heart surgery to a person whom you don't have faith or not experience. But a 302 will be subjected to be decided by a man who doesn't even have the basic law degree also.
Lordship.
Your Mercedes car, will you give it to your neighborhood garage? Never. If necessary, you'll ship it to Delhi for the appropriate showroom. Why? Why the neighborhood garage man cannot deal with your Mercedes car? He can also do it, but he'll never do it.
No, he can't do it. Mercedes is too
About
complicated.
20 years back in Bangladesh, every car was an imported car. And the repairing was, it was put in a ship sent to Japan to get it repaired and again brought back. Why? In spite of the permissibility of the law, will it be appropriate that a person's fate under 302 will be decided by a person?
No, authority option. Go to civil court.
This possibly, yes. If you can show from your records that, yes, we have people who are competent to do that. As we are also have the power under the force code to deal with such matters, in our enrollment, we have also kept people who are competent for this. If the record speaks of that nature, say, you are a force. Why do you have a medical department? Because there is an anticipation that the force people may also require medical treatment. So we also have a medical department in place. So if the force court can also decide cases of 302, we should also have put in place a person competent to do it. As you have put a doctor for the treatment and you are not sending that treatment to any Havaldar, do you send a person ill in your force to a Havaldar? A regular Havaldar for treatment? No. You have a doctor in place.
Here, in fact, Lordship, as per the rules, there is a law officer who guides the proceedings. But how far the
No, no.
competency is concerned, Lordship,
Again, the law officer depends on his competency.
that is what.
Law officer alone will be the doctor to whom will not allow your open heart surgery to be done. How do you reconcile that? Everything. These are larger issues.
Yes, yes.
If the law permits you to do it, there is also a corresponding requirement that the appropriate personnel should also be available and in place for doing it. Otherwise, it's only an enabling provision. The law enables you to do it. So let us today fix the modalities in how we will proceed. Then you come prepared, we will also hear. Read also the administrative law principles, how an enabling provision is to be interpreted or acted upon. Maybe you'll find something there. Otherwise, this is a very abstract question. You won't get any direct decision anywhere. I don't think you'll.
It's not coming. It's not there.
But here is a case, this question is raised, we are bound to answer.
Yes. By the way, there are decisions like force court has given, it has been upheld, but this particular question,
This-
whether they are.
It was not raised
It was
earlier.
not. It was not.
Plus Article 21. Life and liberty cannot be taken away. Except under the due procedure of law.
Yes.
And due procedure of law also includes a fair trial. Fair trial includes the concept of a competent person conducting the thing. Not an enabled person. Competent
Yes.
person. So this is where maybe we can proceed in this line. Number one. And number two, what about 156 CRPC?
Investigation.
Huh.
From the record.
Because your rule 41 speaks about trial.
Transfer.
About trial. Before trial, there has to be investigation.
It appears, Lordship, some witnesses were taken from which,
Investigation.
yes, by
So,
the court of
no,
inquiry.
this is what we are trying to ask you. 156 gives the authority to the police or any other authority to investigate. Is a similar power of 156 available in the BSF Act?
It will be under the court of inquiry, Lordship, the fact finding.
Which one? Section?
Court of inquiry. Court of inquiry to vote.
Where is that force court provision?
Force court, Lordship, will find at section 65 to 68.
65. And inquiry?
The inquiry, Lordship, that is the court of inquiry. I'm trying to find it, Lordship. Right.
Minus 65 procedure of security force,
65.
or rule 65.
Court of inquiry.
Security force, court of investigation.
Court of inquiry is a complete concept. Court of inquiry. 16.
Investigation. File to competent one of the like on investigation. If the investigation part to hand. Investigation file will never.
See, here's a note to that section 72, in which jurisdiction court can examine as to whether authorities have complied with the requirements of law and regulation. Requirements of law,
Yes.
that will expand the scope to even Article 21.
Yes.
So we can examine.
In any case, Lordship, the Constitutional Court has.
So once we examine that requirement of law.
Court of inquiry, Lordship, will find in Rule 170 of the BSF rules. Court of inquiry, Lordship will find in Rule 170 of the BSF rules 1969.
So now come to section 80.
It. Lordship.
When a criminal court and a security force court each have jurisdiction in respect of an offense, it shall be the discretion of the Director General or the Inspector General, Deputy Inspector General, within whose command the accused is serving, or such officer as may be present, to decide before which court the proceedings will be instituted. Discretion. And what is discretion? And what is the basic difference between the whim and the discretion? Generally, it's
Whim with me without any reason.
and
Discretion, there has to be some reason.
reason. So will this discretion also not include that the force has a competent person to decide it? So we are deciding it.
That has to be there.
Can't we strike it at this stage? That whatever discretion was used was not a discretion under law. It's
That may be the ultimate decision of the court after hearing.
no, we are
Yes.
trying to chalk out the modalities.
Yes, yes.
Can this be one of the modalities? Discretion vis-a-vis Article 21. Okay,
Lordship,
is it parted?
Minus,
Already parted.
already part.
List for further hearing. So
can it be in the second week, Lordship, of
on any date you choose.
second week? Can it be?
The date you choose.
Last night, yes, sir. Lordship, on Thursday, 10th.
In course of the hearing, a question for decision has arisen as to whether, although it may be permissible under section under section 72 of the Border Security Force Act 1968, read with section 46, providing for civil offences as also one of the offence under the Act. To conduct a trial in respect of an charge under section 302 of the Indian Penal Code. Whether such trial can be conducted by the General Security Force Court without there being a competent and eligible person to conduct a trial under section 302. To be also included in the composition of the General Security Force Court. And also, what would be the significance and relevance of the discretion to be exercised by the Director General or the other authorities under section 80 of the Act as regards before which court the proceedings are to be initiated. We framed the question, we'll try to answer it. This also is very straightforward.
17. 17.
Copy of the order be made available to Mr. R.K.D. Chaudhary. Because the question we have set, we take a
Yes.
copy and you,
17.
Yes, yes. This has to be answered sometime.
you take the view of the department
Yes.
on this basis. Means we are not that you are not entitled. We are on the
Entitled, but competent.
competency,
I have
a
got
competency and discretion.
discussion cannot be simply like that.
So relevance of the expression. Discretion.
Much of it.
You produced a voters list.
My lord, in the additional page 66, 96 onwards, my lord.
Yes, have you read the complete voters list?
Yes, but I have seen it, but only the issue was that the Mozumdar has come.
Sorry.
The title Mozumdar has been added, my lord, later on. That is the only discrepancy so far as.
Alamuddin Mozumdar.
Yes.
Alma,
Alma.
In the later voters list, Mozumdar added.
Added.
Earlier voters list, no Mozumdar.
No Mozumdar was there.
my lord, 1966, my father's name is, my lord, Abdul Latif. Mazumdar was not there, my lord. Village, everything is same, my lord. Constituency was the same, my lord. 2005, for first time, my name appeared, my lord. With my father.
Does the list having Mozumdar as the surname also has another Almazuddin without Mozumdar?
That, my lord,
Then it will be very clear that the two were different person.
that I have to. Make it.
Apart from this, otherwise,
Otherwise,
sometimes the voters list are not that perfect. Somebody
fact, the
Mozumdar may
Majumdar-
have been deleted. At one point of time, he thinks that my Mozumdar should be reflected in the
Yes,
voters
yes.
list. He makes application, gets it there.
Majumdar title has been added to the whole family, my lord.
Whole family,
Yes.
everybody becomes Mozumdar.
Earlier total list, I was trying to get.
Possibly they thought their status will be enhanced by becoming Mozumdar. The Mozumdar will be knowing. No, the whole family added the surname Mozumdar after one particular list. So maybe they thought that their family status will be enhanced by adding the word Mozumdar,
Sometimes it happens.
which had already happened. Initially, the name was Almazuddin. From one particular year, Mozumdar had been added, Almazuddin Mozumdar. So we call for the entire voters list of all those years. This is the information coming. But perhaps Almazuddin without Mozumdar is not there anymore.
No,
No.
no.
If two persons would have been there, then you can say that this Mozumdar Almazuddin is a different person. And not only one man, the whole family added the name Mozumdar. What to do?
2005 of this.
একেটা হয় না মানে। It's a fine, same solution. You make a verification and find out. Go to their house and let somebody verify and submit a report. Otherwise, neither we can accept it nor we can reject it.
That issue, your lordship remanded.
Heard, Mr. J.
Lashkar.
J. Roskar Land Council for the petitioner. Also heard this one. The petitioner Almaz Uddin Majumdar was referred to the Foreigners Tribunal. Which page is the order of the tribunal? Huh? Page number?
Page number 2, my lord. Title page. In read petition.
No, where is the order?
Order, sir. Order. Lordship, page 81.
Was referred to the Foreigners Tribunal Dima Hasau at Haflong for rendering an opinion as to whether he is a foreigner under the Foreigners Act, resulting in registration of FT case number 42/2017. The tribunal rendered an opinion dated 28/3/2018 declaring the petitioner to be a foreigner. Being aggrieved, district petition is instituted. Okay, so case number 42. No. 42/42. What is page 52?
My lord, on being remand, my lord. This is the original opinion, my lord, page 52, my lord.
Huh.
Thereafter, we approached this honorable court, my lord.
Actually, it was sent back.
My lord, sir.
Then the next
Not
opinion
that.
was rendered. In the writ proceeding, the petitioner relies upon the voters list of
1966, my lord.
1966 of village Sipur part 3,
Lordship, sir, part 2.
part 2, Moza Rupair Bali Pargona in the Lokhipur subdivision of which district?
Kacha district.
Of Kacha district, which contains the name of Abdul Latif, son of Siddiq at serial 167, Altu Bibi, wife of Siddiq Ali at 168, and Ang Hanid, son of Siddiq at 169. The voters list of 1970 of village Shibpur Part 2 contains the names of Abdul Latif, Altu Bibi, Ang Hasid, and Moina Bibi, where Moina Bibi is the wife of Ang Hasid. What is Ang?
Instead of Abdul, my lord, they used to the Ang.
Why do you write Ang?
My lord, 185, my lord.
No, Ang is a Burmese name.
My lord,
In Burma, they write Ang.
in Barakvali, they party used to do, my lord, instead of Abdul, in my case also, Lashkar, they will write long. Instead of writing entire Lashkar, my lord. But they used to do this every week.
Why it is happening like that in Barak Valley?
I don't know why.
Now, how a name can be changed?
My-
Whether you are from Barak Valley or any other place, a
My-
name cannot be changed. Name is a proper noun.
My lord,
Proper noun is a proper noun.
My-
It is only that name what the name is about.
My- so in page 98, my lord, kindly have a look at
नाम
page
तो बदलो
180
तुम्हारे मन में।
184. Ang.
No,
Second,
initials can be written.
My-
Say you are saying J Loskar.
My-
J must be having some name. So you can call yourself that complete name or you can call yourself J Loskar. But the word name J, whatever it is, that cannot be changed and put into a different form.
my-
Even if you are from Barak Valley.
My-
Unnecessary confusions. Yeah, Herish. The 1977 voters list of village Shibpur Part 2 contains the name of Abdul Latif, Altu Bibi, Abdul Hamid, Moina Bibi, Abdul Hanan, and Abdul Karim. Page 111 होता से side दी वो. All being either sons or wives of Abdul Latif. Almas. Now, where is Almas?
My lord. Page.
Similarly, the voter list of 1985 contains the name of Abdul Latif and Moina Bibi.
My lord, page 104 of my.
104.
My lord, original 105, my lord.
105.
Start from 383. my lord.
The voters list of 2005
2005.
of village Shibpur Part 2 contains the name of Abdul Latif, Moina Begum, Mohimuddin, Jaifaluddin, Sapna Begum, along with Almazuddin, Abdul Latif Mojumdar,
Mazumdar.
Moina Begum Mojumdar, Mohimuddin Mojumdar, Jaifaluddin Mojumdar, Sapna Begum Mojumdar, along with Almazuddin Mojumdar. Petitioner accordingly claims that the burden under Section 9 had been discharged inasmuch as the name of the petitioner Almazuddin Mojumdar appears along with Abdul Latif Mojumdar and others whose names also appeared in the earlier voters list of village Shibpur Part 2 from the year 1966. Mr. J. Paing, Land Counsel for the Home Department, has pointed out that the earlier voters list did not contain the surname Mojumdar, whereas the voters list of 2005, the surname Mojumdar had been included, which again raises a question as to whether the persons are one and the same. In view of the award remanded back to the tribunal, the respondents to the Home Department to make a verification as to whether Abdul Latif Mojumdar of the 2005 voters list, along with Almazuddin Mojumdar and Abdul Latif of the earlier voters list of from 1966 onwards of village Shibpur Part 2 are one and the same person, and thereafter some report before the tribunal. Upon doing the needful reason order be passed, the respondents to also verify as to whether the writ petitioner Almazuddin Mojumdar and Almazuddin Mojumdar of the 2005 voters list of village Shibpur Part 2 are one and the same person.
Alright.
Upon doing the needful reason order be passed.
Item 60 for admission.
Dev Choudhury was here. He said he can appear on behalf of the National Commission.
Mr. Argedi was here, must
He
have
was,
gone for some other matter.
No, Lordship, in court number 1, he immediately.
What will you do? You wait for some time.
After some time.
Just explore that aspect, whether we can interfere with that direction of the National Commission and send it back to the National Commission to conduct the inquiry. Because they will have jurisdiction over Madhya Pradesh.
Yes, yes. They have the same
And,
power,
uh,
same adjudicative power at the same state commission.
And if necessary, they can take the help of the Madhya Pradesh
Yes,
Commission.
Yes, yes.
But they cannot ask the Assam
Yeah.
Commission to inquire somebody of something of Madhya Pradesh.
Assam Commission, particularly for that purpose, sent it to the National Commission.
Ah.
He rightly sent, but it was sent back. All right, Mr. Datsuri.
Mr. Chaudhary, will you appear for respondent number 2? National Commission for that child protection.
Lordship, I will accept notice, otherwise it.
No, no, we're passing the order itself.
Lordship can record. Otherwise it will be, it's a long pending matter, Lordship.
What happened? The
I'm
son
aware,
of this petitioner, he was traveling in a train in Madhya Pradesh. There are some information. He made a phone call to his father that he was in little distress and he was in the custody of some railway police. Next, we have is some postmortem report. One stand is taken by somebody that the call was at 7:45. Postmortem report says died at 7 p.m. These are not very relevant for us. Postmortem report time is not absolutely accurate. But the approach that Assam, what is the full form?
Assam State Commission for Protection of Child Rights.
Assam State Commission for Protection of Child Rights. They had made a complete synopsis of the events. Also raised questions that the death appears to be in a mysterious circumstance, which requires an inquiry. Addresses it to the National Commission. National simply says, retorts back to the Assam Commission, say, you investigate, you make the inquiry. So now that had taken place in Madhya Pradesh. Assam does not have jurisdiction over Madhya Pradesh. So they have rightly requested the National Commission. So the National Commission did not perform its legal duty and sending it back without any application of mind. So we are going to set aside that communication and ask them to take cognizance of this report by the Assam Commission, do the needful. If necessary, you can take the help of the Madhya Pradesh Commission, who may have jurisdiction over the matter.
Yes,
This is what we intend to pass.
yes, Lordship.
And unfortunate father, he only wants that there must be some inquiry. That's what he wants. He doesn't want anything beyond that. His son is gone, already gone. At least I'll be happy to know what had happened.
Yes, yes. Yes, Lordship.
And he is entitled to know. Please come to page 25. And turn to the previous page. The previous page is, I think, starts from page 22 or 23. This one is addressed directly to the National Commission. I think.
Yes. Yes.
And see the copy two at page 24, number 1.
But, 25 is too mechanical.
But that is not a judicial order. We think we can interfere.
Yes, it's
It's not a judicial order.
not a judicial.
Only it happened that the communication at page 22, which is addressed to the chairperson, National Commission of Protection of Child Right, a copy there was also given.
Yes.
This copy is given, either you do it or don't do it. You cannot do something contrary.
Uh, I was just inquiring whether 25 signatory was the chairperson.
That's what this Lordship is also asking, but
No, we said
possibly no.
20.
Because if you come to that copy to serial number 1 of page 24,
To intervene.
But
it's addressed as just Supreme Court of India. It's not addressed as a
even 25, this is his official pad. This is 25, this is his official.
official badge as a judge. But this is not a judicial commission. I think we can interfere. Not interfere, we'll provide without taking note of this one, the National Commission to take cognizance of that report of the State Commission at page 22, take necessary action to conduct the inquiry.
There is nothing from the National Commission.
They have not done. So there the legal right may have been violated. They sat over the matter without doing anything. What is your prayer in the petition?
Inquiry,
Take an inquiry.
page 15.
Inquiry.
Why an inquiry into the death of the petitioner son should not be made in terms of the provisions for
So
the.
if we direct the National Commission. It will be met. So let them do it. Take note of that area and do the needful, including conducting an inquiry, either by itself or any competent authority having jurisdiction over Madhya Pradesh. And submit a report. Submit a report to whom?
Inform the petitioner.
The copy to him.
And and page 25, we ignore it.
That is not. And why a copy was sent, that is also.
That is also I wanted to ask the respondent, why did you send a copy? For nothing. There is no requirement to send a copy. Or was the particular judge in charge of any such committee, etc., who was dealing with National Commission of Child Rights or something like that at that relevant point of time?
Yes, there, nothing is discernible.
And it's in the personnel pack, not as a commission or anything.
Yes.
Heard Mr. P.K. Roy, learned senior counsel for the petitioner, also heard Mr. R.K.D. Chaudhary, learned deputy SGI for the respondents in Union of India, including the respondent number 2, namely the National Commission for
Protection of child rights.
Protection of Child Rights. The son of the petitioner namely Biswajit De, left his house on 19/10/2014 by intimating the petitioner that he was going to the Paltan Bazar area in Guwahati for purchasing a mobile handset. And he took a sum of rupees 2,000 for the purpose from the petitioner, saying that he will return back soon. But as it happened, Biswajit De did not return back to his house. When Biswajit De did not return on 19/10/2014 and 20/10/2014, the petitioner lodged the FIR before the local police station. Which local police station?
It's a Lalganj, though it's not there.
A local police station regarding the missing of Biswajit De. On 21/10/2014, the petitioner received a phone call at about 5 a.m. from an unknown number, where the caller identified himself to be a Railway Protection Police staff member of Piperia Railway Station in the state of Madhya Pradesh. And the caller intimated the petitioner that he had recovered the son of the petitioner on being handed over by the guard of Lokmanya Tilak Express, which was traveling towards, which was traveling from Guwahati to Mumbai. The caller also intimated the petitioner that Biswajit De was recovered in a subconscious. What is subconscious? There is a subconscious mind.
I don't know, it was written in the
Must have been
complaint.
either semi-conscious or unconscious or something. There
Written
cannot
in
be
the
a
complaint.
subconscious. Was recovered, intimated that subconscious state. As the petitioner was astonished as to how his son could have reached the Piperia railway station, he requested the caller to allow him to talk to his son. And when the petitioner talked to his son on the cell phone of the unknown caller, the petitioner could realize that his son was in a terrified state of mind, and he was saying only one thing, that they are all involved, and please come over and take him back, or else after crossing the border, the persons may kill him. The aforesaid aspect and the aforesaid circumstances and the subsequent circumstances are stated in detail in paragraph 5 of the writ petition, which is extracted as below. Do you have a soft copy?
I can
If
give.
possible, give it.
I-
Otherwise, they have to type one or
Lots.
hold 1 or 2 pages. In paragraph 6 of the writ petition, it is stated that in paragraph 5 of the writ petition, it is stated that the petitioner received a call from a cell phone number for a cell phone bearing number 9752418732 at about 7:49 p.m. Wherein the caller had inquired from the petitioner as to whether he had already boarded a train from Guwahati, as well as the details of the coach number in which he was traveling. But in paragraph 6, it is stated that after about 2 minutes of disconnecting the call made at 7:49 p.m., the petitioner received another call from the cell number 9752418732 from a person named Birendra Yadav, who had informed the petitioner that his son had run away from the custody. Full stop. In para 7, it is stated that Birendra Yadav, after about 20 minutes later, after about 20 minutes from the earlier call, informed the petitioner that his son had died after being run over by a train and said that he had slipped while he was trying to climb onto the train and had died on the spot. Upon reaching in para 8, it is stated that upon reaching Piparia railway station, the petitioner was taken to the morgue where the body of his son was kept. When he reached the People's India on 23/10/2014. 2020, he was people. Morgue, where the body of his son was kept for identification. It is also stated that Birendra Yadav had told the petitioner that the death of his son took place at about 7:15 p.m., whereas the last call made in the aforestated cell phone was at 7:45, which again is an inconsistent situation. We'll continue at 2 o'clock. All of the whole of we'll come back at 2 o'clock. Then we'll go for the state about the, even if you don't come, we'll mention about this communication by the State Child Protection Authority address to this thing, then this happened, then we feel that as per required by the, there is requirement, let the National Commission conduct an inquiry and submit it.
T.
In the circumstance, the petitioner approached the Assam State Commission for Protection of Child Rights The some state, in short, ASCPCR কৰি থৈ দিব, হা? The ASPCR call for reports from authorities, including the Director General of Assam, as well as the Director General Civil Defense and Home Guards and the Additional Director General Police CID Assam on the issue of death being caused to the son of the petitioner. The Superintendent of Police CID Assam submitted a report by memo number CID/Roman 6/R/133-15/172 dated. He did very good. What is the date? Page 21, Mr. Roy? I dated 10/2016. Pagi kini blank. Huh? 1, 2. No. It is 01 or 02. 02 is the month. 02 is the month. There is no date. It could be, which is available as Annexure B, page 21 to the writ petition. And purport of the report of the Superintendent of Police CID is that there was no information that the disappearance of the son of the petitioner was related to human trafficking. Be that as it may, the chairperson ASPCR submitted a communication. Submitted a communication bearing number ASPCR brackets C58/2015/51 dated 17/7/2017 to the chairperson, National Commission for Protection of Child Rights, bracket in short NCPCR. The communication dated 17/7/2017 is extracted as below, including the copy to of DD. Do you have any soft copy? No, this one. Scan kori phale keteba eto tan dibo pari. Printer hote scan thake keteba. A reading of the communication dated 17/7/2017 makes it discernible that the ASPCR was of the view and also made recommendation for reinvestigation of the matter, in as much as, according to ASPCR, there was serious doubt as to how the postmortem report stating that time of occurrence of the death to be 7:15 PM, whereas the father of the petitioner claimed to have spoken to the dead boy at around 7:49 PM of the same day. Further, semicolon, as to under what circumstance the boy was apprehended by the police at Pipersenia railway station and why, semicolon, what could have possibly happened that compelled the boy to run away from the safe custody of the police force, semicolon. The date of issue of the ticket found from the body of the boy was 18/10/2014, whereas the boy went missing on 19/10/2014, semicolon, as well as that the runaway from the custody raises serious question on the standards of security provided by the police. Be that as it may, it is also noticed that the said communication was also addressed to Justice Madan B. Lokur, Honorable Judge, Supreme Court of India, for favor of his kind intervention into the matter. The record reveals that Honorable Justice Madan B. Lokur had made a communication addressed to the chairperson of the ASPCR, which is dated 27/2017, which is extracted as below. A reading of the communication dated 27/2017 makes it discernible that the said communication was with reference to the suspicious death of a child named Biswajit Dey, and further that the ASPCR may take up the matter itself. At that stage, from that stage onwards, the matter of inquiry on the death of the son of the petitioner did not proceed any further, resulting in institution of the present writ petition with a prayer for an inquiry on the circumstance of the death of the son of the petitioner. Full stop. Para 10 of the communication dated 17/7/2017 of the chairperson ASPCR makes it discernible that the death of the the contents of the communication data so and so makes it discernible that the death of the son of the petitioner took place in the state of Madhya Pradesh. And although the ASPCR was of the view that the death required further inquiry, but because of the jurisdictional issue, the ASPCR was unable to make any further inquiry and accordingly referred the matter to the NCPCR for doing the needful so that justice can be meted to the deceased son of the petitioner, as well as to ensure that no further lapses in the system procedure may lead to victimization of any child. Fundamentally, we are in agreement with the communication of the ASPCR that the matter required an inquiry to be made by the NCPCR, inasmuch as the ASPCR had a jurisdictional issue to carry forward further inquiry on the matter. From such point of view, it can be said that it was for the NCPCR to take up the matter and carry the inquiry further and do the needful, and if necessary, to also involve the State Commission for Protection of Child Rights of the state of Madhya Pradesh. full stop. But it has been informed that because of the communication dated 27/2017, requiring the ASPCR to take up the matter further by itself. And because of the inability of the ASPCR to carry the matter forward as the inquiry is required to be stayed in the state of Madhya Pradesh, the matter had not proceeded any further. In the circumstance, without giving any relevance to give without giving any relevance to the communication dated 27/2017, which required the ASPCR to take up the matter itself. We direct the NCPCR to take note of the communication dated 17/7/2017 from the chairperson ASPCR and do the needful as regards the death of the son of the petitioner, which, as per the contents of the said communication, had taken place somewhere in the Piparseria railway station in the state of Madhya Pradesh. The NCPCR, upon doing the needful and completing the inquiry, may provide a copy of the report of such inquiry to the petitioner for his petitioner, which in our view would serve the purpose of the present writ petition. Writ petition accordingly stands closed with the aforesaid direction to the NCPCR. Anything different could have been done. That communication is not relevant, so don't act on it.
Item 61.
Yes, Madam Chaudhary. FT case. Page 50. Why do you want to read? Why do you want to read? No, that is understandable. That is understandable. The petitioner is before this court because you were declared to be a foreigner. Now you discharge a burden under Section 9 that you are not a foreigner.
One certificate she was produced by her, which is issued by the Gaon Bura.
Gaon Bura.
Yes,
What does the Gaon Bura provide for?
Election and
What does he provide for?
She is the daughter of Fajorani.
So this certificate, just a minute. So this certificate establishes a relation between the petitioner and her father. Which provision of the Evidence Act provides for the procedure to be adopted to establish a relationship? Sorry, Section 5. Section 5 of what? Section 5.
Her father is an.
No. First you see whether the procedure,
Lordship may kindly see the order, my lord.
it is not section 5. To establish a relationship, it is section 50. 50. Evidence section.
Have a table, my lord.
To establish a relationship, you are trying to establish a relationship that that person is the father. So section 50 is relevant. What are the requirements of section 50?
And the court has to form an opinion as to the relationship of one person to another. The opinion is expressed by conduct as to the existence of such relationship of any person who as a member
Just
of-
slow. Of any person who as a member of the family or otherwise. So your Gaumbura is otherwise. He's not a member of the family. So what he has to do, read further. Has special means of knowledge.
the subject
Ha.
is the
What special means of knowledge does the Gaumbura have?
counter.
Special means of knowledge.
That which she was born,
So are we to understand that a Gaumbura knows everything in this world?
because record remains with the ground.
A record. Which record maintained by the Gaumbura shows that so and so is the father? Is there any record with the Gaumbura? Record. Okay. Who appears for the Gaumbura? Who appears for Gaumbura? You appear. Does the Gaumbura maintain any record which will indicate who is the father and who is the daughter? Do you have any, do you maintain any such record? No. They don't maintain. Gaumburas don't maintain any record as to who is a father and who is a son or who is a daughter. So therefore, the Gaumbura must have special means of knowledge. That, what name you said? Fazlur. That Fazlur is the father of, Fazlur Ali is the father of Hamida. So, as section 50 is not satisfied, this certificate has no value.
Like the ground was also not examined.
He may not be examined also, but even if he is examined,
Comes the records with the ground, my lord. In the office, release the document.
you find out what record the Gaumbura is maintaining. We'll call for the records.
Yes.
You represent the Gaumbura. A claim is made in this petition that the Gaumbura who had given the certificate, which one? Page number?
Before,
Page 54.
Mixer L.
Was given the certificate at page 54, annexure L, maintains a public record which would contain the information that Fazlur Rahman is the father of the, Fazlur Ali is the father of the writ petitioner Habida Khatun. If any such record is available, the records may be produced before the court. Or else you say we don't maintain any record. Madam Chaudhary, no such record is there. Give a copy of the writ petition. There is nothing that 2017 copy cannot be given. But Madam Chaudhary, for your information, there is no such record.
They maintain register. So they
Are you sure? Okay. Let the Gaumbura respond. What record he gave. Let them elect. Now we'll follow democracy. There are two matters. One that foreigners that rights of way for declared foreigner and another some tax matter. Which one to take up?
Ours is, my lord,
No, you decide amongst yourself. So that's why I say democracy.
but we have completed our part. In our case, argument is almost over.
Hmm. Oh, we wanted some information on that revenue villages. The analysis of the information given on the number of existing revenue villages.
My lord, but then if things that, let the matter come next week. But I will inform
Monday.
This matter.
Yes.
Monday.
Monday.
You analyze the information is already provided to the court.
Madam,
You just analyze and tell us how many villages came into existence after 1970. That's all.
Lord,
We don't
Monday.
want anything beyond that.
Yes, I will inform the revenue department.
I think they can easily work.
Yes,
out
yes.
If they actually want to do it. And even if it is not complete, at least some indicative
some, yes, in respect of one or two.
districts
major,
or whatever you do.
Monday.
Adjourn on the prayer of the respondents to be listed on Monday. Monday we shall receive.
27. On Monday.
You don't observe anything?
Yes.
And the
কি বলে?
Just propose,
থাক না লাগে list on Monday.
object না করে।
মানে
I-
listed on Monday, man.
Item 22 to 53 for hearing.
My lord, item number 9 was there, can it be taken after next? That's all.
9, I think there is a request from Mr. Mahmood to have it adjourned.
This is.
See, here it is.
My lord, your lordship directed me to examine the 9 judge bench judgment of the apex court.
This
That
one,
is, my lord, in
this one.
2007-12 SCC. Look, here it is not there.
Sorry.
It is in the book, my lord. This compilation, it is not there. Compilation, right? In the compilation, it is
No,
not
no,
there.
this is the judgment.
So this is judgment by X. I'm sorry. My lordship, take to page 122 of the SCC. So the majority judgment was by Chief Justice Justice Thakur.
Thakur for himself, Sikri, Khanvilkar.
For himself, Justice Sikri, Khanvilkar, Bobde, S.K. Singh, Ramana and Bhanumati. And concurring, and Chandrachud J and Bhushan J merely dissented.
Same thing.
I will also make kindly take to page 127, where the questions were formulated. Para 11.
So this is by a 9-judge bench. And 7 of them,
My lord.
they form the same view. 2 of them dissented.
Para 11, my lord, at page 127. At the bottom of the page, my lord. At the hearing before us, the learned counsel for the parties agreed after a dual exploratory exercise that the question that falls for determination by this court would be reframed as under. Can levy of,
To frame the questions, day long.
my lord, bear on.
For framing the questions,
My lord, before,
a day-long exploratory exercise.
before the custodian bench, my lord, of the 5 judges, whether the matter should be, 2 judges, my lord, whether matter need to be referred to the larger bench, it took 5 days.
No, to frame the question, it took 1 day. 1 day of hearing.
Say, my lord. Can the levy of,
Prior to this, there was what my learned friend is indicating.
5 days by the 2 judges, whether to refer or not to refer.
earlier 5 judges, then 2 judges, again, earlier 2 judges, then 5 judges, then 2 judges again, then refer to the 9 judges, and 9 judges also 1 day for
For framing the questions.
Can the levy of a non-discriminatory tax per se constitute infraction of Article 301 of the Constitution of India? Second, if answer to question number 1 is an affirmative, can a tax which is compensatory in nature also fall foul of Article 301 of the Constitution of India? And next, what are the tests for determining whether levy or tax is compensatory in nature? Next, is the anti-tax levied by the states in the present batch of cases violating Article 301 of the Constitution, and in particular have the impugned state enactments relating to anti-tax to be tested with reference to both Article 304A and 304B of the Constitution for determining their validity. Now thereafter they say, my lord, para 13, whether non-discriminatory fiscal measures also impede the trade, commerce, and intercourse, and thereby fall foul of Article 301 of the Constitution, can be answered only if one keeps in view the constitutional scheme underlying separation of powers in a federal system of government. Governments like the ones chosen by us. The answer would depend on the way we look at, understand, and interpret the provisions of the Constitution, and in particular the provisions of Part 11, 12, and 13 thereof. Interpretation of these and every other provisions must have due regard to what are recognized as the basic feature of the Constitution. In doing so, the approach of the court can neither be rigid nor wooden or pedantic. Being a living and dynamic document, the Constitution ought to receive an equally dynamic and for examining that how the Constitution is to be examined. You also may skip over because I also may come to my lord. Page 130. He says, para 16. Having said so, we must sail smooth on certain fundamentals before we address the question whether levy of tax per se operate as an impediment or restriction on the right to free trade and commerce. Now, the question which they are examining, you'll also find the bottom, power to tax and attribute to sovereignty. So there is no dispute about that, the power tax is an attribute to the sovereignty,
Para 17.
Para 17. It says power to levy tax had been universally acknowledged as the essential attribute to sovereignty. Cooley in his book, so they are discussing about that is of the only sovereignty, so there is no dispute about that. That is the power of sovereignty. You lost it, may skip over below. Then page 132. They are para 21, they are reading the Article 265, the power of taxation under the Constitution. So this is general discussion.
Page number 100.
132 below. para 21. So this is a discussion on Article 265 of the Constitution of India. And I think you're also well aware, so there is no need of reading below Article 265 of the Constitution, what are the power of taxation and all those things. I think my lord, we can skip over because if we read all my lord, well, these are general discussions. Thereafter, you also can see page 134. Para 24. The limitations on the exercise of the power. Exercise of the sovereign power is however subject to constitutional limitations, especially in a federal system like ours, where the state also, to the extent permissible, exercise the power to make laws, include laws and the levy taxes, duties, fees. That power to levy taxes is subject to constitutional limitations, is no longer res integra. A constitutional bench of this court has Synthetic Sowing Chemicals Limited recognized that in India, the central and state both enjoy the exercise of sovereignty power to the extent the constitution confers upon them that power. So there also need not be, because in part 2 and part 1, list 1 and list 2, several powers were conferred on the center and both the state. So that I think below your lordship may unnecessary going into it. I think
No.
that
We don't know anything.
I don't,
We don't know anything.
your lordship knows everything, but to say that your lordship does not know, that is a, but I think that this is may not be necessary also, because
Para
That-
24.
well, that is, there is no dispute about it. This is all history and all those things. Now we come to para 27 at page 137. The marked difference in the approach adopted by the learned counsel for the parties in this appeal is also a measure of the complexities of the issues that fall by determination. This is especially so because the prevailing legal position in terms of the judgment of this court in Atiabari and automobiles cases holding that the physical measures that are compensatory fall beyond the mischief of Article 301 has been questioned by both the sides. So both the sides, my lord, said that compensatory nature of theory was not correct. Both the petitioners as well as the respondents. Mr. Harish Salve, who led the forensic exercise followed by so-and-so, so-and-so and so-and-so, others vehemently argued that the compensatory tax theory propounded by the 7-judge bench of this court in automobiles case has no legal basis or constitutional sanction and was neither acceptable nor workable. This is particularly so because the state legislatures had taken umbrage under the compensatory tax theory and declared the fiscal levies imposed by them to be compensatory in character and claimed the same to be outside the mischief of Article 301 and consequently immune from the challenge on the ground that these taxes and levies were
Unreasonable restriction.
unreasonable restriction on the right of free trade and commerce. The state which have enacted the laws providing for levy of taxes on the entry of the goods into local area within the meaning of NT 52 of list 2 have on the other hand similarly contended that compensatory tax theory is benefit of any legal basis and the decision of Atiabari and automobile cases need to be revisited to restore the protect the sovereign power of legislation of the states and the federal character of our
So
polity.
one side argues that compensatory tax theory has no basis. State argues that in exercise of its sovereign power, this concept should not be brought in as a impediment to impose the,
Both the sides were so far as
but
compensatory,
for two different reasons.
but compensatory tax, both the sides said that no.
No, and two different reasons. One says it has no
Yes.
basis, other one says that cannot
Sovereign
be a
Sovereign power.
sovereign impediment to the
But they
sovereign
challenge
power.
both the complicity tax theory which was propounded by Atiyabadi Automobiles, and they say that this theory is not correct. Suffices to say that except a feeble attempt made by some council, there has been a general consensus that compulsory tax theory deserves to be rejected and issue examined afresh on a true and correct interpretation of the relevant constitutional provisions. We are mentioning all this to show that even after 50 years and several eliminating pronouncements of this court, the levels of the judicial opinion as to the true and correct legal position on the subject continues to loom large and haunt every lawyers and litigants. And if we may say so, even judges alike. The present reference to a larger bench is in that backdrop expected to give a quietus to the raging legal controversy of the considerable complexity, though given a reservation of the litigants and the ingenuity of the bar acquired is only a pious hope and has and may even in future elude us. So this is the background, my lord, of the dispute before the controversy before the apex court. Then you'll also may see, my lord, they are discussing the general principles, the constitutional limitations must be expressed. That also, my lord, I think is not necessary to look into because this is a general principles. And we may skip over, my lord. And we come to page 145, para 38.
It's 138.
Para 138.
138, sorry. Page number?
145.
Para 38.
My lord. Before we turn to the provisions of Article 301 to 307, comprising Part 13 of the Constitution, we need to also bear in mind the historical background in which the part of the Constitution was enacted. While doing so, we must, at the threshold, acknowledge that the historical perspective of Article 13 has been explored several times during the past in the several pronouncements of this court. The exposition of different stages of the evolution and development of what comprises Part 13 today has been both extensive as well as the incisive. The decisions of this court have gone into great details. While examining the history of Part 13, it will therefore be presumptuous for us to suggest that the historical basis of Part 13 is vision area, which transfers for the first time in the fairness to the scholarly pronouncements that have proceeded the present batch of the cases. We must acknowledge with gratitude the usefulness of the in-depth study of the understanding of the judges who have examined and traced the evolution of Part 13 while drawing their conclusions from the same. No matter with such inferences and conclusions have more often than not been varied, which is but natural when the examines history of events that so and so party. So here the court was, my lord, again examining the evolution of Part 13 of the Constitution.
What is Part 13? Yes, sir.
My lord, they are discussing about the Part 13. We may skip over and may come directly to page para 58. Page 157. It is in this above background that question number 1 shall have to be answered, which turns on a true and correct interpretation of Article 301 of the Constitution. We must at the threshold say that while attempting to answer the question, we are not on virgin ground, for this court has in Athiabadi company case examined the matter great length. The decision of this court in automobile case has modified the view of the Athiabadi, bringing the concept of compensatory tax, which the court held to be outside Part 13 of the Constitution. While J.C. Saje in Athiabadi took the view that all taxes, regardless of whether they are discriminatory or otherwise, would constitute an impediment on the free trade and commerce guaranteed under Article 301 of the Constitution of India, Sinha CJ held that taxes per se totally outside the purview of Article 301 and could never constitute a restriction except where the same operated as a physical barrier that prevented free trade and commerce and intercourse. The view taken by Saje was not supported by any one of the counsel appearing for the parties, for it was candidly accepted that the same was an extreme view that was legally unsupportable. What was all the same argued on behalf of the dealers, SSCs, was that the majority view that propounded the test of the direct and immediate effect from free trade, commerce, and intercourse was the correct view. Reliance in particular was placed on the learned counsel for the dealers and SSCs upon the following passages appearing by the majority judgment authored by Gajadnagar J to contend that the same propounded the correct legal position. Thereafter, the passages of Milord Athiabadi had been reproduced. I think we can skip a passage, minute. We may come to para 16, at page 159.
Let us read that passage.
Well,
It will be help us getting it a more clearer picture.
Certainly, I will read, my lord. Let us now revert to Article 301 and ascertain the width and amplitude of the scope. On a careful examination of the relevant provisions of Part 13 as a whole, as well as the principle of economic unity, which is intended to safeguard by making a said provision, the conclusion appears to be inevitable that the content of the freedom provided for in Article 301 was larger than the freedom contemplated by Article 297 of the Constitution Act of 1935, and whatever else it may or may not include, it certainly includes movement of the trade, which is the very essence of all trade and its integral part. If the transport or the movement of the goods is taxed solely on the basis that the goods are thus carried or transported, that in our opinion directly affects the freedom of trade as contemplated by Article 301. If the movement, transport, or the carrying of the goods is allowed to be impeded, obstructed, or hampered by taxation without satisfying the requirement of Part 13 of the Constitution, stating the freedom of trade on which so much emphasis is laid by Article 301 would be illusory. When Article 301 provides that trade shall be free throughout the territory of India, primarily it is the movement part of the trade that has in mind, and the movement or the transport part of the trade must be free, subject, of course, to the limitations and exceptions provided by the Article 13 of the Article 13, Part 13. That we think is the result of Article 301 read with Article 301, other articles in Part 13. Thus, the intrinsic evidence furnished by some of the articles of Part 13 shows that the taxing power laws are not excluded from the operation of Article 301, which means that the tax laws can and do amount to restrictions, freedom from its which is granted to trade under the said part. Thus, that means that all tax laws attack the provisions of Part 13, whether the impact on trade or its movement is direct or immediate, or indirect or remote. It is precisely because the words used in Article 301 are very wide and in a sense vague and indefinite that the problem of construing them and determining them is exact width and the scope becomes complex and difficult. However, in interpreting the provisions of Constitution, must be bear in mind that the relevant provision has to be read not in vacuo, but as occurring in the single complex instrument in which one part may throw light on another, so and so. In considering Article 301, we must therefore have regard to the general scheme of a constitution as well as the particular provision in regard to the taxing laws. The construction of Article 301 should not be determined on purely academic or doctrinal considerations. In considering the said articles, we must adopt a realistic approach and bear in mind the essential features of the separation of powers on which our constitution rests. It is a federal constitution which we all are interpreting, and so the impact of Article 301 must be judged accordingly. Besides, it is not irrelevant to remember in this connection that the article we are considering imposes a constitutional limitation on the power of the parliament and the state legislature to levy taxes, and generally, but for such limitation, the power of taxation would be presumed to be for public good and would not be subject to judicial review or the scrutiny. Thus considered, we think it would be reasonable and proper to hold the restrictions freedom from which is guaranteed by Article 301 would be such restrictions as directly and immediately restrict or impede the free flow of the movement of trade. Taxes may and do amount to restrictions, but it is only such taxes as directly and immediately restrict trade that would be within the purview of Article 301. The argument that all taxes should be governed by Article 301, whether or not their impact to trade is immediate or mediate, direct or remote, adopts, in our opinion, an extreme approach which cannot be upheld. If the said argument is accepted, it would mean, for instance, that even a legislative enactments prescribing the minimum wages to the industrial employee may fall under Article Part 13, because in an economic sense, an additional wages bill was indirectly affect the trade and commerce. We are therefore satisfied that in determining the limits of the width and amplitude of the freedom granted by Article 301, a rational and workable test applied would be, does the impugned restrictions operate directly or immediately on trade or its movement? It is the light of this test that we propose to examine the validity of the act under the scrutiny and present proceedings. So the apex court, it was observed that the restrictions must be direct and immediate.
So only such taxes as directly and immediately restrict trade that would fall within the purview of 301. This is the purpose of this provision. And the view of Justice J.C. Shah was not accepted by anybody, which says that all taxes, regardless of whether they're discriminatory or otherwise, would constitute an impediment to free trade. So this was an extreme view. This is not accepted by anyone. What is accepted is
immediate and
directly and immediately restrict trade. Okay.
Now, para 16, on behalf of the respondent states, it was per contra argued that the power to levy taxes is sovereign power that remains totally unaffected by the Article 301 of the Constitution of India. Free trade and commerce intercourse was not, according to the Learned Council, to be understood as from any restriction, leave alone free from taxes, which the state legislature were otherwise competent to levy. Initiation law clause.
This para 50 quoted in that page, para 59.
My lord.
This is the passage who authored that passage?
My lord, this is
Justice
mentioned, my lord.
Shah or Sena?
Justice Sinha ji.
No, authored by Justice
the-
Gajendra
the-
Gadkar, I think.
The Shah was not operational. Gajendra ka ji, my lord,
Gajendra Gadkar J authored
the judgment.
that paragraph 50. Now Athiabari, their Attorney General is relying on paragraph 14.
My lord, thereafter they are relying on
And this is by Justice,
Sinha
Sinha.
J judgment at para 14,
this is relied upon by the Attorney General.
my lord. And the learned counsel appearing in the state, the correct view which ought to have been accepted in preference to the other two contrary views propounded by the judgment. Reliance in particular was placed by Mr. Odgi and learned counsel for the respondent states upon the following parties appearing on behalf of Sinha J judgment and Athiabadi so and so.
So dealers rely upon the passage by Justice Gajendra Gadkar and Attorney General relies on the
Para 14 of the Sinha J.
Justice Sinha.
It says, look, used from all comprehensive sense, taxation on trade, commerce, and intercourse would have many ramifications and would cover almost the entire field of the public taxation, both in union and the state list. It is almost impossible to think that the makers of the Constitution intended to make trade, commerce, intercourse free from taxation in that comprehensive sense. If that were so, all laws of taxation relating to sale and purchase of the goods or carriage of goods and commodities, men and animals, from one place to another, both interstate and intrastate, would come within the purview of Article 301 and the proviso to Article 304B would make it necessary that all the bills or amendment of the pre-existing laws shall have to go through the gamut prescribed by that proviso. That will be putting too great emphasis impediment to the power of the taxation vested in the state and reduce the state's limited sovereignty under the Constitution to a mere fiction. That extreme position has therefore to be rejected.
So
As-
this is rejection of Justice J.C. Shah's
My lord,
view
my lord.
that
That it will come not come at all.
that all taxes regardless
Are
of
outside.
whether it's will be outside the
My lord.
reserve.
In this connection, it is also pertinent to bear in mind that all taxation is not necessarily an impediment or restraint in the matter of trade, commerce, intercourse. Instead of being such impediments or restraint, they may on the other hand provide for vitals to improve different kind of the means of transport. For example, in cane growing areas, unless there are good roads, facility and transport of the sugarcane fields to sugarcane mills may be wholly lacking and insufficient. In order to make new roads as also to improve the old ones, cess on the growth of the cane or other intended in the transport of this commodity has to be imposed and has been known in some parts of India to have been imposed as a certain rate per MD of the ton of the sugarcane transported to sugar factories. Such a imposition of is a tax on the transport of sugarcane from one place to another, either intra-state or interstate. It is the tax which is realized that markets is feasible for operating new means of communication or for improving old ones. It cannot therefore be said that taxation in every case must mean an impediment or restraint against the free flow of trade and commerce. Similarly, for the facility of the passengers and goods by motor transport or by railways, a surcharge on usual fares is brought to be levied or may be levied in future. But such a surcharge improvement in the means of the communication may not be available at all. Hence, in my opinion, it is not correct to characterize a tax on movement of the goods and passengers as a necessary connoting an impediment or restraint in the matter of the trade and commerce. Thus, that is another good reason to support the conclusion that taxation is not ordinarily included within the terms of Article 301 of the Constitution.
For this logic in paragraph 15, it can also be viewed that the state is taxing these trades not as an impediment, but to facilitate the trade. Suppose they take a stand that we use this money raised out of the taxation to provide for a peaceful atmosphere, peaceful situation, so that the trade can take place and it grows further. So then it going by this logic, that is also a reason why it is not an impediment. Because only when the government has the money, they can bear the expenditure of maintaining peace and harmony in the area where these trades are taking place.
Well, there are different taxations entries,
Hmm,
like tax on the entry of the goods,
uh,
taxation of luxuries,
hmm,
tax on sales and purchase, all other the entries are there. Now, the purpose of every, like luxury tax or anti-tax or the tax on sale are altogether different. Now, it cannot be said that they all are for the purpose
No, I
of.
am saying by the
No,
logic
that's
in
correct, Milord.
Uh-huh.
That's correct.
logic in para 15 says that
In general, Milord,
good roads will be provided for the sugarcane growing
in
areas.
general, Milord, there is no dispute about it.
Hmm,
But that's why, Milord, the compensatory tax theory, when
hmm.
it came for the purpose that you should not utilize the money for general purposes. If you are realizing
But only for the purpose related to that particular trade where it is taxed.
for the purpose of development of the road, I can understand
Hmm,
where the for movement of these things are there,
hmm.
but not for the general purposes of the state.
Like,
Needs, Milord, the general is there, somewhere, Milord, the hospital is open. That is not for the purpose of the amount which is collected from the traders for movement of the goods.
hmm.
Milord, there are certain responsibilities, like preparation of the red drains in the,
No, these imaginations have no limit. Suppose the interstate trade that will take place,
silo.
if it is taxed and you say the good hospital is created, if a good hospital is created, the people of that area will be healthy. They will be able to consume the traded goods more.
They are,
If, on the other hand, if the people are not healthy, they won't be able to consume these goods.
here is not for the purpose of consumption. It is realized from the person
Understand.
on the transportation.
No.
goods.
Here, transportation, we understand. What is the purpose of transportation? So that these goods are ultimately available in that market of that area. So the people of that area will consume these goods.
So in that sense,
So your trade will go.
in
So
that sense,
see, we are not observing anything.
in that sense,
We
I
are
just
indicating.
adding, Milord,
Suppose you say the hospital. They may take a view that when there are good hospitals in existence in that area, it will generally maintain good health of the people. Once the good health of people are good and healthy, their self-income will be more. And this self-income can be used to consume the goods you are bringing to the market. But if the people are not healthy,
absolutely.
their income level will be less. So ultimately, so it is indirectly to facilitate the trade.
Milord, in that sense, if you say, then
No,
giving the scoot-
That's what
No,
I'm saying.
I'm
We are
just-
not observing anything. We are just,
I fully appreciate, Milord. I'm also expressing my.
we are just saying.
Milord, I'm just expressing my. views. So in
okay.
that way, Milord, the giving the scooties to the students who have got passed in the first division. That may be also make me say that no, if the scooties are there, they may go to school, they may be better education will be there. Ultimately, they will be become as good students.
Scooty, they say there's an encouragement.
That's why, Milord,
Ha.
whether the
A
transportation,
computer given,
well, the amount which has been collected by the way of tax on the transportation, if we take the view of the hospital good health, then ultimately that will also have a effect, ultimate result.
No,
will be the-
ultimately, these are never-ending thoughts.
That's why I'm saying,
In
Milord,
other words, there's no limit to these thoughts.
that if we go by that analogy, Milord, then every money and every expenditure by the government, we say that every expenditure is the government is for the public good. The advertisements, they collect the money, they give on the advertisement. We may say that, no, the advertisements by that people may come to know the benefits of the government is giving, and ultimately the benefit will be. So ultimately, it has also a connection. So every money which is expended,
And the more the tax collection is of the government, the more they can spend it for the welfare of the country. And the more it is spent for the welfare, the general state of the country will be such that it will be more conducive for better trade and commerce.
My lord,
Say now, the government is procuring some aeroplanes, some submarines and all. This will give a good security to the country. That is the idea. When the security of the country is more enhanced, the economic activity in the country will be more. There will be more investments in this country from outside. Once the investments are more, the economic activity is more, the general economic level of the people will go up. Once the general economic level goes up, consumption will go up. Once the consumption will go up, these goods that are sought to be brought in spite of there being a little higher tax, you will be able to sell more of the goods. Suppose with a lower tax, you sell 10 units. Now with a higher tax, because of the better economic condition situation that has been brought in, you'll be selling 50 units.
my lord,
So ultimately, your level of profitability will be
my
more.
lord, there are various theories.
That's what I said.
My lord, I am of the view, like one.
That's why I'm saying there are no end to this theory.
Well, I will submit it this way. We always shout that the corruption, we should stop. I say more the corruption, more the development of this country. I personally,
Because the corrupt and will spend much more money and that
corruption
money can
person
be
will spend the
circulated.
money. he will purchase the refrigerator, he will purchase the car, there will development of the industry of the car, there will development of the freeze, refrigerator, and all those things. And secondly,
But difficulty is corruption has no constitutional sovereignty.
a person who's
But
keeping
whereas the tax has the
a
constitutional
person who's
sovereignty.
keeping the money, corrupt money,
Ah,
he will expend. Because
Understand.
tomorrow the election is there.
But there is no constitutional sovereignty.
I am submitting, my lord. Well, I am submitting, my lord. He will make the expenditure on the election release and all those things. The people will get the money. They purchase 100 rupees, 1,000 rupees for getting them in the
Understand.
release.
Ultimately,
money is going-
ultimately, you are trying to say that corruption is good for circulation in the
You know, the
economy.
GTM may go to 15%. If the more corruption is there, otherwise the money will be all, the money which is there, they will be lying at one place. Nobody will take out. But if somebody is asking for the bribe, that person who's keeping the money in his, this one, safe boxes, that will have to go. And it will go to the channelized to the
Because, sir,
general.
elect the next government which will legitimize these acts.
Well,
They pass a legislation.
Well, there was an income tax. One person filed a petition claiming expenditure of giving bribe as a business expenditure. He said that this is business expenditure without, if I don't give the
Forget
bribe.
about that. In one of our neighboring states, these bribes are taken in demand draft.
But in some certain state, there is no question of
It's
demand draft.
taken in demand draft to ensure that the payment is there. Otherwise, somebody may say, I promise you 10 lakhs, but he may not give 10 lakhs. He may give ultimately 5
My
lakhs.
lord, the
So you pay the money in demand draft. I'll deposit in my account first and then I'll
you know, the
accept.
state from which earlier I was over there, Mr. Now. The AG is sitting here.
It's a fact of that state only.
My lord, that, in fact, that
It's a fact,
state,
in fact,
that
that
state.
issue had come up.
That state is contributing a lot for the general development of the country. Because the money is all paid in cash everywhere. Now that money is expended by the people. So they bring the money goes from center to them. From there, corruption and all those things, it comes to the people to the back. They make the expenditures, it goes for development, purchase and all those things. So the development is there. They stay in the hotels, very costly hotels. Hotels are developing very good cars, expenditure. So everywhere, you know, it has a link. So if we analyze in that way, so it has a link. Instead of the money lying with two persons, it's better that it comes out and goes to the general public.
You vouch for a legislation.
You know, if I speak all those things,
We can impress upon the advocate general. He may initiate moving of such a legislation.
well, if we make,
Before
if we
he-
legalize, legalized.
Dr. Saraf, we are not on that.
No.
No, we are just responding to para
Well, I was
15.
just, outside the case which is there, I'm not speaking whatever is there for 15.
Para 15. This, what I'm saying, there is no limit to
That's
this particular thought process.
Well, if you examine this angle, we will feel that this is also correct. If you examine this other side, then also we will feel
But
that this is also correct.
basically, everything will have a constitutional sanction regarding para 5. But the other examples you are giving may not have a constitutional sanction.
No, nobody knows, my lord. The
Unless
constitution is a
you
living,
impress
my lord.
upon Mr. Chaudhary to bring in a constitutional sanction for
My lord,
this.
constitution is a living thing. It changes with the time. And with the changes with the time, the amendments have to be made. Who knows, my lord, after 10 years, 20 years, the situation is like that. The constitution may be amended. What is there? 150, 105 amendments are there. What is there? We have to keep view the situations. The amendments will be necessary. Another chapter will be added, like the taxation, like the bribery, corruption.
That we cannot accept it for the time being
I was
unless
thinking of
you.
writing I was thinking of writing an article on this.
Dr. Saraf, you may write article, but for us,
No.
we
I-
cannot take,
My lord, I cannot say, and myself also,
we cannot take note of
Well,
that
I also cannot.
till you bring a constitutional sanction
My
for
lord, I
that.
also cannot,
Once you bring it, we'll take note
because
of
if
it.
I say so, there may be problem. So, my lord, the view of Sinha Ji,
If a law is passed at legislature.
or the conclusion of Sinha Ji is at page 61,
Para 61.
para 61. And at para 62,
So say that 301 is subject to non-discriminatory restriction
my lord.
imposed by Parliament in public interest. Even discriminatory preference may be made the Parliament.
That is only my lord, whatever they were there in 301 to 304, they were stated. Now there are para 62, the court examining the automobile transport.
So an automobile case,
My lord,
a further concept was brought in,
compensatory tax.
compensatory tax.
My lord.
And here, what is the conclusion in para 61?
My lord, the conclusion you
Conclusion
have
is
seen,
that is subject to non-discriminatory restriction.
my lord, that was,
So if the restriction is discriminatory,
that is, my lord, obviously there is a provision itself that non-discriminatory, but it said, which is the Gajendra
No, no.
Gajay,
how do you understand this para 18
para,
quoted in para 61?
I think I'm reading, my lord. Thus, on a fair construction of the provisions of Part 13, the following proposition emerge. Trade, commerce, and intercourse throughout the territory of India are not absolutely free, but are subject to certain powers of legislature by Parliament or the legislature of the state. The freedom declared by Article 301 does not mean freedom from taxation, simpliciter, but does mean freedom from taxation which has the effect of directly impeding the free flow of trade, commerce, and intercourse. The freedom envisaged by 301 is subject to non-discriminatory restrictions imposed by Parliament in public interest, Article 302. So that Article 302 empowers the Parliament to impose reasonable restrictions. Even discriminatory or preferential legislation may be made by Parliament for the purpose of dealing with an emergency, like a scarcity of goods in the part of country. 3032. Reasonable restriction may be imposed by legislature of state in the public interest. Non-discriminatory taxes may be imposed by legislature of state on goods imported from other states if similar taxes are imposed on goods produced and manufactured in the state. 304A. And lastly, restriction.
So ultimately, if the taxation has the effect of directly impeding the free flow of trade and commerce,
That was in Athiabari.
Athiabari, so this is the view of Justice Sinha in Athiabari. Then, if it is directly impedes the free flow, it is unacceptable in law. If it does not directly impede, it can be imposed. Any test given? Any test given? How to evaluate whether it is directly impeded or it is
That
directly
the 9
not
judges have dealt
impeded?
with the restrictions and all those things.
Uh,
The 9 judges have dealt with what is the restriction and all those things.
What will be?
Para 62, my lord, the Constitution 7 judge bench of the automobile transport.
Hmm.
Before we examine the rival submissions, we must also refer to the decision of this court in automobile case, which added a new dimension to the legal exposition Athiabari case by declaring that taxes that were compensatory in nature fell outside Part 13 and could never be treated as a restriction offensive of Article 301 of the Constitution. S.K. Das J, speaking for the majority, explained the concept of compensatory taxes falling outside Part 13 in the following verse. As the language employed in Article 301 runs unqualified for the court, bearing in mind the fact that provision has to be applied in the working of an orderly society, has necessity to aid certain qualifications, subject to which alone that freedom may be exercised. This point has been very recently discussed in the dissenting opinion of Fulagar J, wrote in so-and-so, an opinion which was substantially approved by the Privy Council in so-and-so, and the learned judge gave several examples to show the distinction between what was merely permitted regulation and what was merely inference, true inference with freedom of creative commerce. He pointed out that in the matter of motor vehicles, and countries have legislation which requires that motor vehicles to be registered and a fee to be paid on registration. Every motor vehicle must carry lamps of a specified kind in the from and end and to rear, and in the houses in the hours of the darkness. These lamps must alight if the vehicle is being driven on the road. Every motor vehicle must carry a warning device such as horn. It must be driven at a speed or in a manner which is dangerous to the public. In certain localities, a motor vehicle must not be driven at a more than a certain speed. The weight of the load which may be carried on a motor vehicle on a public highway is limited, and such examples may be multifarious and indefinitely. Nobody doubts that the application of the rules like the above does not really affect the freedom of trade and commerce. On the contrary, they facilitate the free trade of commerce. The reason is that these rules cannot fairly be said to impose a burden on a trader or deter him from trading. It would be absurd, for example, to suggest that the freedom of trade is impaired or are hindered by laws which require a motor vehicle to keep it to the left of the road and not drive in a manner dangerous to the public. If the word free in Article 301 means freedom to do whatever one wants to do, then chaos may result. For example, one owner of a motor vehicle may wish to drive on the left of the road while another may wish to drive on the right of the road. If they come from opposite directions, there will be an inevitable class. Another class of example relates to the marking of a the making of a charges for the use of the trading facilities such as road, bridges, aerodromes, etc. The collection of a toll of a tax for the use of the road or for the use of the bridge or for the use of the aerodrome is no longer not a barrier or burden or detriment to the traders who in their absence may have to take a longer or less convenient or more expensive route. Such compensatory taxes are no hindrance to anybody's freedom so long as they remain reasonable, but they could of course be converted into hindrances to the freedom of the trade. If the authorities concerned really wanted to hamper anybody's trade, they could easily raise the amount of the tax or toll to an amount which would be prohibitive or deterrent to create other impediments, which instead of facilitating trade and commerce would hamper them. It is here that the contrast between the freedom, Article 301, and restriction, Article 302 and 4, clearly appears, that which in reality facilitates trade and commerce is not restrictions, and which in reality hampers or burdens trade and commerce is a restriction. It is in the reality a substance of the matter that has to be determined. It is not possible a priori to draw a dividing line between that which would really be a charge for the facility provided and which would really be deterrent to the trade, but the distinction, if it has to be drawn, is real and clear. For the tax to become a prohibited tax, it has to be a direct tax on the effect of which is to hinder the movement part of the tax. So long the tax remains compensatory or regulatory, it cannot operate as a hindrance. The conclusion below, you'll also find it page 165, para 17. We have therefore come to the conclusion that neither the widest interpretation nor the narrow interpretation conversed before us are acceptable. The interpretation which was to be accepted by the majority in Athiya Coinso is correct, but subject to the clarification. Regulatory measures or measures of imposing compensatory taxes for the use of the trading facilities do not come within the purview of the restriction contemplated Article 301, and such measures need not comply with the requirement of the provision Article 304B of the Constitution. So the Athiya majority view was accepted, but
bringing in the concept of compensatory tax also. I think this is the purpose of that.
Then the dissenting judgment of Hidayatullah J. Hidayatullah J in his dissenting judgment, however, took the view that even when a tax may be compensatory in character, it would be valid levy only if it goes through the process of presidential assent in terms of Article 304 of the Constitution of India and the provisions thereof. So the Hidayatullah J took a dissenting view that even if it is compensatory,
he had accepted it, but it should be routed through the method of presidential assent. But on principle, he accepts it.
My lord. Then again, 64 Subba Rao, he also agreed with the majority view, adding the following passage to the same. The next question is, what is the content of the concept of freedom? The word freedom is not capable of precise definition. We may skip over because ultimately it is a dissenting judgment. Para 65 is the net effect.
(65) says that
The compensatory
direct
taxes,
and substantial benefit to the taxpayer.
my lord,
and declare that it is not just a remote benefit to the taxpayer, but a direct and substantial to justify compensatory.
My lord. When the matters, my lord, relating to anti-tax were pending before the apex court, the matter was referred to the constitution bench.
Yeah.
And that is, my lord, in para 65 last part.
Hmm.
I may read, my lord. There were two judgments of the apex court in Bihar Chamber of Commerce and Bhagat Ram's case.
Hmm.
Now, because the two judgments which were contrary to the
Hmm.
automobile transport, the matter was referred to the constitution bench in Jindal.
Hmm.
And Justice Kapadia ji, my lord, that observed, and you'll also find the para 49 in paragraph 65, the judgment.
That is after 5 days.
My 5 benches judgment. This
No,
is 5.
this is after deliberating for 5 days.
No, 5 days. This was, my lord, earlier decided by Justice Umapal.
Acha, division bench, 2 judges took 5 days.
No, this was, my lord, not 2 judges. After that, 2 judges was there.
They took 5 days.
My lord, this was after the Bhagat Ram and Bihar Chamber of Commerce. There were conflicting judgments. So the matter was referred to the constitution bench. And the constitution bench in Jindal Stainless followed the law laid down on automobile transport.
So whatever facilities are provided as a compensatory measure, that should be for better conduct of that trade,
Right.
not all other trades.
Not general, but the benefit must accrue to the person,
Good.
maybe remote.
To that trade,
Okay.
persons involved in that trade, then it will be compensatory. So it will be justified.
So the constitution bench, 5 days bench judgment, my lord,
Hmm.
that you will also find para 66. The legal position that
So
today,
now, suppose they introduce a entry tax on good X. Good X is entering the state, good X is also manufactured and sold in the state. The benefit that has to be given as a compensatory tax, that benefit should be accrued to those traders who are involved in this interstate trade of that good X. If the benefit is accrued to them, as per this theory, it will be permissible.
other persons also may get the benefit. There is no that was clarified. That other persons.
And
get-
what about the traders involved in the trade of that same good X, which is manufactured in the state?
It says, my lord, that some benefit must accrue to that person. It doesn't say that other persons cannot take the advantage of it. Like road has been constructed. From the road, my lord, I will also get the benefit, other persons will get the benefit. That is not restrictive, but I must get some
So
benefit.
then how do you understand this? Para 65,
My lord,
that compensatory character of a tax has to be determined by reference to the direct and substantial benefit facilities provided by the state to the taxpayer
My
was examined and answered in affirmative in Jindal,
my lord,
while overruling declared that it is not just a remote benefit to the taxpayer, but only a direct and substantial benefit that would justify levy of compensatory tax without offending. So
so it was,
it's not just a remote benefit, but a direct and substantial benefit to the taxpayer.
my lord,
So who is the taxpayer?
it was clarified, my lord.
The taxpayer who will pay this particular entry tax.
My lord, it was clarified.
So that's why I asked you this question,
My lord,
whether the benefit should accrue
My-
to the trader who is involved in trading of that X item,
my
which
lord,
is put in interstate trade.
my lord,
In that means the trader who is involved in the same good X which is manufactured locally, he
My-
should not get that benefit.
No, no, that has been clarified. In fact,
If he gets a benefit, he is having double benefit.
it was clarified, my lord, in this one, that
Ultimately, did any clarity come out or questions are still open?
my lord,
After all these exercise,
No,
did the
after this,
complete clarity just come out or the
90
questions are still
my
open?
lord, the 9 judges bench judgment has come out with the ultimately
Ah,
that
so has complete clarity been brought in?
non-discriminatory tax is no restriction.
That has to be.
It says non-discriminatory tax will not impose any restriction.
So if this entry tax is imposed on the local manufacturer as well as the imported manufacturer, then there is
No,
non-discriminatory.
it says, my lord, it said, also taking into consideration the exemptions, etc., which are given by the state, that it is a burden
Burden on?
of the tax on the person concerned. Because, like in Assam, they say, after entry of the goods into Assam, if the goods are sold within Assam
Hmm.
and the tax under the local sales tax law is paid,
Hmm.
then no entry tax is to be paid.
Hmm.
So if anybody is importing the goods from outside, entry tax is leviable.
Hmm.
But in case he makes the sale of the same in Assam
Then it is not leviable.
and pays the local tax,
Then not leviable.
that's not required. Entry tax is not leviable.
But if the through Assam, if the good goes to another state, then it will be levied.
No, if that goods again goes to outside the state, then the state and goods has not been consumed or sold, then tax is not there.
Entry tax is also not there.
No,
Then where will be the entry tax then?
Entry tax, if I'm a consumer, I'm bringing the goods for my own consumption.
Okay.
Entry tax. will be there.
Suppose you are otherwise a manufacturer of some goods, you are bringing in some kind of raw material that will be used in your production, their entry tax will be there.
Entry tax will be there, and also there will be burden of the CST. Because when I purchase the goods from outside,
CST will have to pay. That is a
so,
totally different
so the
tax.
question which will come.
That you are paying CST as well as entry
Entry
tax for the
tax.
same purpose.
But if I purchase locally,
That entry tax is not
then
there.
only VAT.
Hmm.
So the question which comes up before Lordship, that first of all, the apex code has said
Hmm.
that the exemption can be only for a specified purpose for a limited period.
Exemption
Exemption which is granted by the state
to the local manufacturer.
manufacturer, it can be only for a limited period and for a particular purpose,
Hmm.
like industrialization, industrial policy, and all this.
Hmm.
You can't give a blanket exemption and say that whoever sells the goods into the state and pays local tax will be exempted. That the apex code said no.
Hmm.
You can't give it. Then secondly, if the burden of the taxes on a person who is purchasing in the interstate
Hmm.
is more than purchasing in the state,
Hmm.
then that is a restriction under Article 30A of the Constitution, 4A of the Constitution only. Because ultimately the question is that
The burden on the person who purchases.
purchases. I purchase,
No, I understand that. Suppose I'm a purchaser. I am to purchase that goods. It is also locally available. Standard is equal. Of course, if there is a variation in quality, the question
Then
will be,
different.
it will be different. Now I voluntarily choose to purchase
From
the
outside.
same outside from outside, ignoring the local one, which is equally
you
good.
may take them of the same mobile, Samsung,
Ha.
same
So
brand.
now, if this is my conduct, by ignoring the local product, why should I go and purchase the outside one? Unless I have undue attraction for the outside
Your
goods
lordship asked a very pertinent
by ignoring the local good.
My lord, that's why.
So if this person has a undue attraction for something else, you pay more for
Well,
it.
otherwise, the very purpose of.
No, you
the
pay more for it.
Very purpose of the.
So here, there is no restriction on that. Because the restriction will be on a person who is trying to have an undue attraction for that goods. To overcome that undue attraction, this tax is imposed. You pay a little more, you exercise your undue attraction, buy that goods. We don't mind. Pay a little more for that. So now, where is the restriction of the traders in respect of those goods?
I submit your lordship. My lord, what your lordship is submitting, that if the same goods are available,
It's available, everything
locally.
is equal. Somehow I have a undue preference for
Outside.
outside goods. I don't like local goods. I don't like the local manufacturer. I know the local manufacturer, I don't want to purchase his goods. I want to purchase the goods that is coming from outside, same one. Why? I'll not encourage your trade here. So, to avoid this kind of situations, this tax is imposed.
so that is the basic, the concept of free movement from one state to another.
Here free movement is not affected. Here free movement is not affected because of some undue preferences you are trying to go for that good.
So I may go anywhere. The country is one. Assam, you cannot force me to that you purchase from here only. If that is permitted, then the entire country, some state will say that I impose this tax. If you purchase from outside, then higher. That was prohibited. Article 301, I will place before lordship. That is the very purpose, the central sales tax was imposed. While imposing the movement of the goods from one state to another. That was the reason that state cannot levy the tax. We levy a fixed tax when goods are moving from one state to another. Otherwise, the state may impose much higher taxes. One state may impose any tax, but prior to the CST came into force, the provision was that, my lord, that a person, the country, state may impose the tax on movement of the, while going the goods. Another state may impose the tax.
No, we
when the goods are
understand.
received.
What you are saying, we understand. But
My purpose is.
no, our question is undue preference.
So I will submit. The anti-tax provision is not levy of tax under anti-tax, is not for the purpose of that if the same goods are available, you purchase from here. That is not the purpose. That is the basic, it goes against the basic principles of Article 301.
But otherwise, other than those broad concepts of free trade, I have the right to take my own decision whether I purchase from Kerala or I purchase from Punjab or I purchase here locally. Other than that broad statement, what is the underlying reasons why a man will prefer the same good from Kerala or the same good from Punjab, and he's
I will give example to you.
no, and he is not ready to purchase the local made,
I will take it.
unless the local made good is of some inferior quality or some disadvantageous in any manner.
My lord, I will come to that, your lordship. Online purchases are there. Nowadays, everybody purchases Amazon and all other places, they purchase the goods. It is coming from various places outside the state. Now, the goods when it is sold, sent from the party, he charges central sales tax. So in my bill, the central sales tax will be there. Now the person who is delivering the goods,
No. In this online purchase, every good is not brought from outside.
Assam also will be there.
No, depends on the nature of the goods you are purchasing.
Well, it depends on the various companies.
No, it depends on the goods you are purchasing. most of these online sellers, they have their own stock, own thing in every local area. The purchase may be online from the portal in some other place, in some other state or some other place. But the goods that will be sold will be from that local area, because the delivery is from the same goods which is available here.
I just tell you also,
Even your Amazon is doing that.
my lord, the mobile phone is
See,
available here. Same
you,
company.
no, you order certain goods in Amazon. Certain goods you will say it will be delivered after 7 days. Another goods will be said it will be delivered
In 1 day.
after 15 days. Another goods maybe it will be delivered in 2 hours. Immediately, moment the payment is received. Why? Because the 2 hours goods is already here. It's a local good. Only thing, the selling is through that online portal and not across the counter in any given shop.
Well, I will tell you also. There are various branches in Assam for the various mobile phones. You'll also find everywhere the dealer, Samsung and all those things are there. If I go to that shop and purchase the mobile phone, you will say the better you purchase from online. It will be cheaper for you. Medicine is available here.
No, that is economics. Because this
Not economics, not economics, my lord. You'll also say that why you don't purchase from Assam, which is
so
available.
now your answer to my original question is the person will purchase the goods coming from Kerala because the original price of the goods in Kerala is cheaper.
Look,
Is that a reason?
that may be various regions, business regions.
This is what we are trying to.
There are various regions are there. A person.
So this is the question we are putting, deliberate word expression, undue preference.
No,
If it is,
assuming I accept your lordships.
if it is something on the basis of due preference, we understand it. Don't impede the free movement. But if it is undue preference,
I accept that I give undue preference to the outside. State has no power.
this is why we are trying to examine the state power.
The state has no power.
No, we are trying to examine the
I'm
power.
submitting the region that the act says non-discriminatory tax, where the same goods are also subject to the same tax.
Dr. Saraf, precisely, I am leading you to this answer only. The very word non-discriminatory will be when all other parameters are same. You give preference to one at the expense of the other, that is called discriminatory. But when the parameters are not same because of the element of undue preference, there may be a reasonable
I
classification.
just give you an example. I purchase a mobile phone of the same brand from, not from Assam, from outside. It's available here. Same brand, same quality, everything is available here. I don't purchase. I purchase from outside. If I purchase locally, then I have to pay only local tax. If I purchase from outside, the CST plus the VAT, the entry tax,
You pay more.
I have to pay more.
No. How do you purchase? You go to Delhi, purchase a mobile
No,
phone,
I
put
purchase
it,
the-
bring it in your pocket and come back to Assam.
That is a. if I
Or you order the goods from a shop in Delhi and through interstate trade, he will deliver it to you in Guwahati.
purchase-
Which kind of purchase you are talking
I
about?
purchase coal.
Uh-huh.
My factory is there, I purchase coal. The coal is coming from outside. From Meghalaya, the coal is coming. Now I purchase and use in the manufacturing. If I purchase locally, I have to pay only the local sales tax. If I purchase from outside, I have to pay the CST plus the entry tax.
I understand. This is again the same question back. Why are you purchasing it from us?
I'm purchasing because I'm getting the credit of two months from that person.
Credit.
I may get in the business, may not various things are there.
Okay, you are, that means some financial gain will come out
That
of it.
decision is mine, not, I'm getting the goods from outside, some discount is there.
This is what we are trying to ask you. So that means it is not an undue preference.
No,
It
that's
is
why
the
lies the
example,
restriction.
the example you are giving is an example of due preference,
So, I'm
not
saying,
undue
you know,
preference.
it is very difficult to be explained like restriction. The word restriction is there, this may be restriction, that may not be restriction. Like this is a business decision, a person takes a decision for purchasing goods from outside, he has not, unless until he has some benefit.
We are just trying to
No,
understand.
I'm sorry, unless until he has some benefit, he will not purchase.
So we are just trying to understand by distinguishing between a due preference, the example of coal on the benefit of this credit of 2 months, it's a due preference. Definitely. Suppose you are a builder and Mr. Chaudhary is also a builder. You are ready to give me an apartment with a very easy payment option. Mr. Chaudhary is giving a little difficult payment option. I prefer your apartments,
This will be very
but
difficult.
this is due preference.
So the undue preference also,
This is due preference.
I will try to convince you
So
also.
therefore, I am trying to ask you from the point of view of undue preference.
I will try to convince you also that even if
I think
undue
we'd have to
preference is
write
there,
to- She is having another pen.
that even if undue preference is there,
So this is where we are trying to ask you, under which proposition of law?
I will place before also
Hmm.
that even if undue preference is there to the outside goods, the state cannot impose to restrict it.
I understand, under which proposition?
Place the judgments.
What is the proposition? You place it.
Proposition will not the, otherwise the very philosophy, preference part, that if the same goods is available here, if the same goods is outside available here, and if you don't purchase from locally, then you will be penalized more. That to avoid that, the Article 286 of the Constitution and the Central Sales Tax Act was enacted,
We'll hear you.
that no state shall impose the tax on the interstate movement of the goods.
286. These are very complicated concepts, actually. It's not that we can have a very easy answer to everything.
Interesting, but
But that thing is occurring in my mind,
I have tried my best.
that undue.
I have tried my best.
And all the examples we are giving are due. Due preference is always there because there is a reasonable classification between the two sources. The outside source, for some reason or the other, is more beneficial. You cannot stop me from exercising my right to have the more beneficial source. There I am.
But
There we are agreeing with you.
who will examine now the tax is to be levied? Whether they will come to me and say that you show me that what benefit you have got, you have not
No,
preferred.
we
I will
don't
not disclose.
know. No, we don't know. We'll have to.
I cannot disclose my business.
If you don't disclose, you have, it is undue.
No, a person cannot force me. The state cannot force me that unless and until your trade secrets you disclose.
No, not trade secret.
This is a
Yes.
trade secret. I will not disclose. How the tax can be levied on that basis? Tax cannot be levied on the basis,
So according to you, it will be indeterminable.
like the restrictions, it says, this may be
Understand.
restriction, that may be restriction.
Understand? This distinction will be undeterminable.
And otherwise, you know what you will submit. The Article 286, which was there, and Central Sales Tax was enacted, the very purpose will be frustrated.
Will you continue? When do you?
Tuesday,
It's better we have it more frequently because you otherwise you tend to forget.
on Tuesday, madam. Only tomorrow I will be out.
Only, madam, if it, subject to what my learned friend says, your lordship hears it on Tuesdays and Thursdays, because this case is going to take some time.
It appears we are still on the preliminary stage.
Yes,
The way
we can,
it took some time to frame the questions, we are still at that stage only till now.
this will take time, definitely take time.
Tuesday. Usually one single bench is there.
Single benches.
Means, okay. that's
So Thursday, some other matters are there, so your lordship takes up 2 o'clock.
Definitely it will be 2
Well,
o'clock.
the understanding, let the understanding. be
Or the other option will be, we go almost day to day, say every 1 hour every day we hear.
Then it becomes that little money.
Up to you, but you have to keep waiting every day
And then the other-
till the end of the day.
If I know my lord that it is on Tuesdays and Thursdays, I can adjust my Arunachal accordingly. Because I have to keep going quite frequently. this-
Our order to keys, eh?
Next week on Thursday.
The argument of Dr. Ashok Saraf, learned senior counsel for the appellant,
Petitions,
for the petitioners remains inconclusive list for on so and so forth.
Thursday.
Thursday too.
One way you can look at it is if this distinction is indeterminable, then of course that is one way.
That is because
Mm.
Your lordship reads the interpretation given by Silvai. Silvai starts when he is talking about trade, commerce and intercourse. The first sentence is that it appears that the framers of the constitution have drafted a defective constitution. It has become, and he goes on to say that it has become a lawyer's paradise.
But we can't become survive.
not Silvai, before that, the Constitutional Assembly debates, it has been said.
We have to accept what the constitution is. We can't go beyond the constitution
True.
as long as it is in
This was
place.
just on a lighter vein.
Justice Chandrachud also in 9th bench judgment has noted it.
This is the rights.
This one, all this paradise and all those things. And what is the harm, my lord? Will be lowest paradise.